Good morning. Welcome to today's hearing of the Yurok Justice Commission. Today we continue our inquiry into the Land Injustice Hearing Block 6. I also wanted to acknowledge and pay appreciation to Colin Hunter Jr. for his welcome to country earlier on the rooftop as well. Always really important that we participate in ceremony and practice our culture. As our ancestors, as we've heard through evidence, weren't able to do that because of government policy of the time and direction. If I could, Gunditjmara meeting, Linyan Kokon Kenen Konaterek Bujbim, Yombin meeting, Warandrima meeting, Coolan meeting, Nian Karabanjul Wangwama, Wu, Boka, Bidderong, Purity meeting, Narakitong meeting, Narakitong Ma, Min Mern Mung. So also just acknowledge and pay my respects to the Wurundjeri people of the Kulin Nation, and then recognise that their laws, customs and spirit creator. And we're here to talk really strong on country here today, and great opportunity for us as well. Continue on our old people's voice and strength. If I could please have appearances, Council.
May it please the Commission, Commissioner, I appear on behalf, I appear as counsel assisting for the purpose of these witnesses.
Thank you, Mr. McAvoy.
If it pleases the Commissioner, I appear for the First People's Assembly of Victoria.
What's your name?
Ms. Narayan.
Thank you.
Morning, Commissioners. My name's Gemma Caffarella and I appear on behalf of the State of Victoria. On behalf of the State, I would like to acknowledge that today's hearing is being held on the lands of the Wurundjeri people, and I acknowledge them as traditional owners of this land. Sovereignty was never ceded over this land. The State pays respect to Wurundjeri elders past and present, and I also acknowledge all First Nations people and in particular First Nations elders in the room today and watching online. And I would like to specifically acknowledge the members of the First People's Assembly who are here today. Thank you.
The Commission pleases, we propose to call witnesses from the First People's Assembly of Victoria this morning. The witnesses are here in the hearing room and ready to proceed. And I call Nagara Murray and Reuben Berg. Now, I would first ask Nagara to just confirm for the Commission your full name.
My name is Nagara Kate Murray.
And in the evidence that you're about to give to the Yurok Justice Commission, will that evidence be the truth to the best of your knowledge?
Yes.
And Mr. Reuben Berg, could you tell the Commission your full name, please?
Reuben James Hamilton Berg.
And could you confirm for the Commission that the evidence that you're about to give will be the truth to the best of your knowledge?
Yes, it will.
Thank you. Now, should I call you Nagara?
Yes.
Is there a formality that we ought to observe, a protocol that we ought to observe at this point in relation to a minute of silence?
Yes, the Assembly has requested a minute's silence.
Mm.
And there's a statement that they've asked me to read.
And perhaps if we, perhaps if you make the opening statement now and then we proceed to a minute's silence, that would be appropriate.
The Assembly members pay respect to the warriors of the frontier wars and resistance fighters who made the ultimate sacrifice protecting their country. We mourn our ancestors with the honesty and integrity they deserve. It's Assembly practice to hold a minute's silence to honour those who have passed. We have asked for the Career History website massacre map of Victoria to be displayed as we stand for a minute's silence.
Thank you, Commissioners. Thank you, Ngara. Were there any other opening comments that you'd like to make?
Yes, I'd like to read my opening statement.
Please proceed.
It's a great privilege and responsibility to be part of this important truth-telling process. I want to start by acknowledging the traditional owners of country, where this Office of the Yurok Justice Commission is located on the lands of the Wurundjeri Woiwurrung people. I recognise the care they have for their country and their ongoing work to protect and heal country. And we thank Colin Hunter Jr. for his welcome and smoking ceremony this morning. My family have had strong relationships with the Wurundjeri Woiwurrung over generations, through my grandparents in particular, Pastor Sir Doug Nichols and Lady Gladys Nichols, and my grandparents, Stuart and Nora Murray, and those relationships continue today with the Wurundjeri Woiwurrung and our families. I'm here today in a combination of roles. I'll share my stories as someone with a deep connection to my lands and communities, as a First Nations woman of the Wamba Wamba, Yorta Yorta, Jar Jar Warang, Duraroa, Japagog and Barappa, but I'm also here with Reuben Berg as the co-chair of the First Peoples Assembly of Victoria. I want to acknowledge and thank all the other Assembly members who have come along today to support us. I know many in our communities have faced incredible injustice in their lives, and many carry the weight of intergenerational and collective trauma. I hope our truth-telling and answers to your questions today will contribute to the healing process. Before we get going, I want to try to summarise some of my thoughts about country, as it's sometimes difficult to put into words for those who are not First Peoples what country means to our people. Country is the essence of who we are, and country is in our blood, and our blood is in this country. Our country right across this state hold the markings of our history. This is country that has felt thousands of generations of footsteps and was crisscrossed by all our families. Our country was pristine and plentiful of resources, and we lived in harmony with the lands and waters within our kinship structures, and where the foundation of our relationships was based on our coexistence. We worked alongside and as part of our environments, connecting us to every part of the cosmos. That's lands, waters, sky, stars, plants, and our totems. We had ceremonies and songlines and trade with our neighbouring tribes. We came from ancient jurisdictions made up of tribal territories, laws, traditions, rules and values that were effective for thousands of years, and which tribes continued to adapt and collectively organise themselves. Our people's relationship with this country has been formed over thousands of generations. This unique connection has built up a profound intelligence and specialised knowledge about caring for it. Our old people instilled in all of us a culture of caring for the environment. Their old people told them the same, and we would tell our kids the same. The disruption to our society was catastrophic. Invasion and colonisation saw concentrated and sustained attempts to smash our societal structures and eradicate our people. The colonisers' approach to land management pushed our lands to the brink of ruin, and the colonisers exploited country for the highest short-term economic benefit. The Jar Jar Warang used the term upside-down country to describe the enormity of impacts that colonisation has held on our lands, from land clearing and gold mining. The harm caused by our dispossession cannot be understated, and while the theft may have commenced 200 years ago, the negative effects have rippled down generations and compounded the unfairness. Despite everything that has been inflicted on us, we have survived, and our connection to country remains strong, and our story is in this land. The fight for land justice began with our ancestors and continues today. Land justice is foundational to our journey to freedom, self-determination and empowerment. Today we are faced with a divide between those whose wealth was stolen and those who grew and passed down that stolen wealth. This is what we need to address. This is why we need to negotiate a better, fairer deal for our people through treaty. The Assembly has a strong purpose, and that is to reclaim our people's power and freedom to make the decisions that affect our families and our communities, our country, our lands and waters. In treaty, we have a critical opportunity to heal the land, when we can repair, rekindle and expand our ability to care for country, both the land and our communities will thrive. When that happens, everyone benefits that lives on this country. We have 60,000 years of Aboriginal custodianship of this land. This is what makes our country so special. It has to be protected for future generations to ensure a healed and healthy country for all of us. In closing, I want to thank the York Justice Commissioners and acknowledge the important work they do. In establishing the Commission, we gifted to the Commission the Wamba word, Yuruk, meaning truth, to represent the value of our living culture and the importance of First Peoples being at the centre of the Commission's inquiry. The word Yuruk pays homage to a long line of warriors, men and women, who have fought over generations against the callous, discriminatory and oppressive forces of injustices and human rights abuses against our people. The Assembly has been appreciative, and we acknowledge with the extent to which the Commission has given effect to and respected the significance of this term throughout its inquiry. Finally, on behalf of the First Peoples Assembly of Victoria, we offer our gratitude to the many First Peoples who have shared their stories for truth-telling. Thank you, Tony and Commissioners, and for letting me get warmed up. I feel a bit nervous. Got to try and relax a little bit. And Ruben and I will be happy to answer any questions on behalf of the Assembly. Thank you.
Thank you, Nagara. Now, the First Peoples Assembly of Victoria has provided a submission to York, and that should be in the Commissioner's papers. There's also a statement dated the 11th of April, which you have prepared for this hearing, Nagara. You're familiar with that statement?
Yes, I am.
And the contents of that statement are true and correct?
Yes.
Commissioners, I tendered that statement from Nagara Murray dated the 11th of April 2024, and I understand it will be given a document number in due course. Now, that statement contains a number of matters which are personal to you in relation to your family and ancestors, but it also speaks to matters which are you're speaking on behalf of the Assembly and going to matters relating to treaty. I just might turn to Ruben for a moment. As co-chair, are there elements of that statement that you would adopt?
Yes, there are. Yep.
And you've provided the Commission with the paragraphs of the statement that you adopt?
Yes, I have.
Thank you. Now, there's an intention, Ruben, to come to you when we come to the matters particularly relating to the business of the Assembly and treaty business. But for the moment, we might deal with the matters contained in Nagara's statement about her family history and the continued assertion of authority and resistance that statement involves. Are you able to speak to those matters now, Nagara?
Yes.
If you could proceed, please.
And there's some images that we wanted to share.
They should come up on the screen in a second.
Within my statement, I wanted to share the story of our fight for land rights over several generations. My family's been involved for the fight for land justice, and it continues today through my father, who's in attendance today. And we've been active in the participation of land rights and the movement going right back to 1881. And you'll see on this picture here, picture of my grandfathers, John and Aaron Atkinson, that many of our Yorta people are connected to, that were part of the 1881 Maloga petition, where they called for self-determination and land rights via the petition. And throughout their time on Maloga, they were strong men, brilliant stockmen, and they created a lot of profitable and productive incentives within the mission of Maloga. And I just wanted to touch on that 1881 Maloga petition with my grandfathers there. The next image is of the 1886 deputation to the Victorian Parliament, Sorry, actually that's the actual petition that has our grandfather's name and many other men. There were 42 men from Maloga that petitioned to the governor for land and asking for self-determination. And that's the actual petition that they've all signed. That was in an article that's been handed down to us through our family.
But that petition is being reprinted there in the Sydney Daily Telegraph on the 5th of July 1881.
Yes.
And that's referred to in your statement. And so the wording of the petition was published in the paper.
Was.
Thank you.
And the Maloga petition requested a grant of land stating access to food and water around Maloga had been limited through the destruction of colonisation and exterminated their game. And that was a request that they'd put in around having a bit of their own land to self-determine and to build their own industry. The next image, I'll just refer to my statements just so I can keep track.
Please do.
Is of my grandmother, Nora Murray, and her daughter, Diane, on the river. My grandmother was born at Gunditjmara, lived on the Gunditjmara village until the Gunditjmara walk-off, where she walked off as a teenager with her family, along with a number of residents in 1939 that left Gunditjmara in protest of the way that they'd been treated. So that's a story we all know too well, our Yorta people, around the Gunditjmara walk-off. Next photo, please. This is a photo of our grandfather, Walter Newman, along with other men, Barak and Wonga, and a deputation that was part of the fight for Corandurk. So obviously the Wurundjeri and Wurrung are all too familiar, Sue-Ann, you would be your families and your connections to this image. And my grandfather, Walter Newman, John Logan, was part of that deputation at the time when he was living at Corandurk. And he was a Jara man that came from Central Victoria and travelled around a bit, but this was his time at Corandurk, which he was part of that deputation that's sent to the Parliament of Victoria. Next photo, please. This one's of my grandfather, Stuart Murray. He was heavily involved in the fight for land rights in Victoria, including as the first chairperson of the Victorian Aboriginal Land Council. This is a photo of him at 17. He'd put his age up to go and fight in a war, and he returned to come back and fight another war for his people. And I thought this was of significance, this photo. So I wanted to honour his role in that movement and what he'd aimed to achieve around land rights and land justice. There's a letter on the next image that he wrote as a chairperson of the Victorian Aboriginal Land Council in 1988 to the Premier at the time, John Cain, asking and advocating for a treaty between the Wamba clans of Victoria and the Victorian government to address land injustice, and touched on examples of international treaties that had happened. And that's the actual letter, and I'm not too sure if there was a response to that letter. The next image is of our grandfather, Pastor Sir Doug Nichols. He was involved in advocating for First Peoples throughout his whole life, and he participated in the day of mourning in particular. But this was an image, I think Auntie Marge Thorpe spoke to it this week, around the fight to save Lake Tyers and the protests. So he was active when the Lake Tyers men come down to Melbourne and leading those protests across the streets of Melbourne. The next image is our grandfather, along with his uncle William Cooper and Jack Patton. This was taken at the day of mourning in 1938. He just retired from football not long before this and joined his uncle William Cooper in Sydney, calling out the treatment that they'd been experiencing through Gunditjmara Mission and other areas of Victoria, New South Wales, and that was him as a younger man after retiring from football when he joined the kind of political movement and became more active, fighting for our rights.
Now, there's another picture that you've referred to, this one here.
Yeah, that's my actual father who's in attendance today. And he's inherited that fight from his forefathers and grandfathers and his own father, and that's been carried down over generations. And that's, gone right back over 7, 8 generations that we've continued the fight for land rights. We still don't have land rights. And that's something that he's inherited, that legacy that we all have. All our families have fought hard for land rights, whether it's the Terricks or the Thorpes or the Nicholses, who else is here?
The Bergs.
Fighting Gunditjmara, the Clarks, the Austins.
And the Bergs.
The Bergs, the Booths. I can't see who everyone's here. The Nelsons. All our families have been active and instrumental in that fight for land rights and fighting for our human rights. And that's something that we're really proud of in Victoria, having a long and proud history of activism. And it's a culmination of all those fights and all those struggles that has gotten us to this point today and where we are in the treaty space. So I wanted to acknowledge that it has been generational. It's a responsibility we've carried over time, and we've been fighting for a very long time. So I wanted to acknowledge and pay respect to my father and grandfathers in that statement. So to show that it has been a long fight for us and we're still fighting, and we're going to fight all the way until we get rights in this country and that we're respected, our dignity, our sovereignty, and our people as the first peoples of this land. So, yeah, I just wanted to acknowledge that.
Thank you. Clearly, it's a matter of great pride for you to be able to refer to your father and ancestors in terms of their contribution to the struggle. You talked about your fathers having inherited the struggle, and can the commissioners assume that inheritance is also passed to you?
Yeah, I think myself and Ruben and even all the Assembly members have a huge responsibility that we've carried over from our ancestors and our forefathers and mothers. And yeah, it's a responsibility I think that we carry today.
And is it your expectation that inheritance will pass to the next generation?
Well, that's where we're preparing our children for what they'll inherit. And I hope that they don't inherit that trauma that we've carried and the pain and suffering of our people and where we are, in this point in time. And I think that we can prepare our children for what they'll inherit, and treaties will be our future. And I really believe in that. And I think that it will change, the way that we go forward in our relationships and how we coexist in this part of the country. And it's something that I prepare my child for. She's a treaty kid. So she comes along to chamber and she participates, takes her little notes, and she's understanding, this is our future and this is where we're going. And she knows our stories as well. She knows our stories about our old people, and we teach her that, to instill that culture and have a really strong knowledge base of where she comes from.
Well, thank you very much for that. I just would give you the opportunity to make any comment you'd like to make, Ruben, in relation to the matters that Nagara's just spoke about from your own perspective.
Yeah, just echo a lot of what Nagara said about that sense of us, all of us as members of the broader community, not just the Assembly community, building on the legacy of our ancestors before us to come to this place. I did also just want to reflect on something that came across me during the minute's silence, and having that massacre map up there, which I think is relevant to the nature of today's conversations. And I was taken back actually during that minute's silence to a time when a great time of celebration, really, that I was down on country with my family, down near the Hopkins River, actually on Blacks Falls and Mount Emu Creek, and was there with my cousins, and we're having a big, fun day in the sun, swimming in the waterhole, and coming back to how our people for generations would have been using that same waterhole for that same purpose, for coming and celebrating and just having fun with family. And then whilst I was there, I was reminded that upstream from that spot was a massacre site where our people had been massacred. And I was struck for quite some time that I couldn't shake the sense that there were likely parts of our family in that water with us that was still there. And so it was this celebration, the joy of being on country, but tinged always with that sadness of that those things from the past never leave us. And it was still that sense of, we were bathing there, still where our ancestors, their blood had been spilled, was still in that water.
Commissioners, I've proposed to move on to some other parts of Ngara's statement at this point. Are there any questions that you might have in respect of the evidence that we've just heard?
Can I just thank Ngara for telling your story? And although you've probably told it and standing in this space, the space of truth telling and telling that, and I just want to honour that, because it's hard. It's a hard thing to do, and particularly when you've got a whole assembly behind you. So, and I know it's difficult. So I just wanted to thank you for doing that.
Thank you, Commissioner. Ngara, I just wanted to ask you now to turn to have you got your statement in front of you?
I do.
If you could turn to paragraph 54. There's a expression in the statement that you referred to in your opening statement, and that is in talking about European approach to land management. You say that it's pushed the land to the brink of ruin. In adopting such an approach, the colonisers have actively shunned our generations and wisdoms of wisdom and practices. The Dja Wurrung used the term upside down country to describe the enormity of impacts that colonisation has had on our land, from gold mining and land clearing. Can you just explain for the commissioners your understanding of what the term upside down country is intended to convey?
Yeah, that's something that JARA have articulated around upside down country and the environmental disruption and fragmentation of country due to the gold rush and the land clearing that's happened right across the tribal territories of the Dja Wurrung. And that's something I think, JARA will speak to, but definitely through their Dalkunyadja strategy around their plan to try and turn their country back into a healthy country is a really big part of their objectives around the rejuvenation, restoration of their country in central Victoria. So that's something that they refer to as upside down country. And it's something that I wanted to touch on out of respect for JARA, but that they can talk to that in more detail.
I want to ask you now that to turn to paragraph 58 of your statement. I'm sorry, paragraph 59 of your statement, where you talk about people other than First People benefiting from country, and you speak about your grandfather not having received a soldier settlement allocation after serving in World War One serving in the army in World War One for Australia.
Yeah, so my
explain that a little bit further, please.
So my grandfather served in the war, and he'd made a number of applications when he returned from his service for soldier settlement land in Victoria and New South Wales, and he was after a sheep farm or mixed farming to be able to come back home to country and to take up a role on his grandfather's land. And he finished third at a ballot at Wagga. That was as close as he kind of got to a soldier settlement farm, and he was married and had kids, and all he wanted to do was really own a piece of his ancestors' land, and that was stolen and exploited from his grandfather, and he was unsuccessful in his attempt, along with a lot of other soldiers. And I know that people like Uncle Johnny Lovett has been part of, the inquiry and has been really instrumental in that call for compensation, for families that, our men that went to war and come back home, and they're poor on their country, and that wasn't afforded to them as it was to the non-Aboriginal soldiers that fought in the wars.
And it sounds, without putting words in your mouth, that you and your family find that particularly offensive or something that is raises anger for your family, in that it's another wave of dispossession, in a sense that land was distributed to other people and not to your family as the real owners of the land.
Yeah, and I think a lot of Aboriginal families would feel that way.
Mm. And so, do you know of other Aboriginal families who have applied for the soldier settlement outcomes?
I know that there's been that attempt through Uncle Johnny and his family in the Lovetts that served in the war, and the families. And I wouldn't want to speak on their behalf, but obviously that's something that they would have considered.
And is the resolution of that issue something that would go some way to resolving the ongoing disputes between First Peoples in Victoria and the government?
Yeah, I think that would relieve some of the anger and what we've inherited through the lack of respect that our Aboriginal soldiers had experienced when they returned.
So at paragraph 61 of your statement, you make the observation that while the inheritance of the colonial descendants was stolen wealth, the inheritance of our peoples was the complex overlapping harm of dispossession.
That's correct.
Now, I just want to take you to another part of your statement where, if you can turn to paragraph 62, and at that part of your statement, you speak about First Peoples' care for country and the notion that everybody benefits from when First People care for their own country.
Yeah.
And you just you've explained it in your statement, but can you just expand on that for the commissioners, please?
Yeah, I think there's a number of examples when we look at the different traditional owner groups, what they've got in place around caring for country and the benefits that provides everybody that lives on their lands. I know that with the Gunditjmara, with Gunditjmara and the work that they're doing on their country is quite significant and contributes to, the tourism industry and the economics of that region. And, everybody benefits for that because it's such a significant site. And, everybody in this country should visit that area at some stage to look at the significance. It's older than the pyramids. It's something of great value, that cultural landscape that the Gunditjmara people, that shows that when they're caring for country and looking after country and they're activating their, aspirations for country, that everyone benefits. So that's probably an example I can talk about around when First Peoples care for country, everyone benefits, or the work that traditional owner groups like the Gunditjmara or the Jara are doing in relation to climate strategies and fire strategies and renewable energy and things that can benefit for all people that live on their countries. And that's what they contribute, to those regions. So there's some really successful, initiatives that traditional owner groups have in place to care for country, and that includes everyone that lives on our country. That's just part of our culture and who we are, that we look after everyone. We have a responsibility to heal the land and to make sure that there's a healthy and balanced country for everyone that lives on it.
Is there something that you would like to add at that point, Ruben?
Yeah, I think often when I talk more broadly to people about the benefits of First Peoples having that capacity to care for country, there's, I think, a very simple analogy that will resonate, I would hope, with most people. And anyone who's ever lived in an old house will know that when you've lived in an old house, you come to know how it works. You come to know that if you want to get to the bathroom late at night without waking people up, don't step on this floorboard here because it's going to creak. You know that if you want to close the cupboard properly, it doesn't quite close, but you've got to, if you push it here, it's going to close smooth. You know these things. When you lived in a place for a long time, you get to know how it works and how to make it function. And so you just take that idea about a house and living it for 50 years and then transpose that to an entire landscape and people living on there for 60,000 years. That's the type of deep knowledge we have about those places to make it run more smoothly, just like you can make your old house run more smoothly.
And do you say that when the house runs more smoothly, everyone benefits from that?
Absolutely. Yeah. When the house is running smoothly, when country is running smoothly, everyone can benefit.
We've often heard the expression that when country is healthy, the people are healthy. Is that something that that you also ascribe to?
Yeah, absolutely. I think that's very true.
Now, in your statement, you refer to some of the types of damage that occur to country, and perhaps it being irreparable, and the need for First Peoples to be involved in the caring for country and the rebuilding of country. When you talk about sort of irreparable damage, what sort of effects are you talking about?
Well, an example is around land clearing, the cattle runs that have come through our country over generations now, and the impact that that's had on our environment. There's a number of legislations, I understand, that associated with environmental issues, so the extraction and mineral resources, the way that that's been extracted from our country, and it doesn't prioritise our environment or conservation, aspirations. So there's been a lot of damage to country right across, all of our traditional owner groups and, our territories that we are responsible for, and that's something that's, impacted the way that we live on that country. And I think, we have such a unique connection to country that we care for our country. We love this country more than anyone. And, when country's sick, we feel sick. We've had to stand by and watch our sites be desecrated and our ancestors be dug up. And there's things that have happened to this country that has been quite, catastrophic in how our relationship is with the land. So I think that there's a lot of examples around country being upside down, as Jara say, and they're working really hard to, fix, the damage to country. And we care for country even if it has been destroyed. It's still part of our country, it's still part of our tribal territory. Our ancestors come from there.
And looking at the upside, when there is a proper role for First Peoples in decision making and the exercise of power, are there any international examples that you can point the commissioners to where the whole community benefits from that role?
There are, and we've looked at a number of international models right across the globe and talked closely with our, connections in Aotearoa with the Maori mob, with the Sami Parliament. Ruben might want to speak a little bit to that. We've talked with British Columbia and, different Indigenous peoples around the globe that have, more power and responsibility for affairs that are related to their, needs and priorities and what they're trying to do to really self-determine and self-govern. So there's a lot of examples that we've considered throughout the treaty process. And do you want to touch on any?
Yeah, I think, as Nagara said, there's lots of really powerful examples. And in the broad sphere of this treaty conversation, we've been really mindful to make sure we draw from those international examples, both in land management, but also in self-determination in those other places, about what the different models are. And I think they're really powerful models to be able to demonstrate to the broader community that you can transfer over responsibility for land management, for water management. You can transfer over decision-making powers to First Peoples, and the sky doesn't fall in, that there are benefits to the broader community when you do those sorts of things. And I'd like to particularly add, in terms of some of the impacts on the environment, from my experience in the water space, I've seen some devastating impacts around how we have mismanaged water in this country. And I was fortunate to have a role as a commissioner for the Victorian Environmental Water Holder. And that sense of upside down country equally applies to upside down waterways, in that so often across this state, what we've seen happen is that our rivers have just been turned into pipes. They're essentially just a mechanism to get water from one place where they've dammed up the river to get it down to some farm in some other place. And so the river's no longer able to actually have its natural cycles like it would. It in fact runs in reverse. So if you think about how a river should work, that when it's winter and it rains a lot, there's going to be higher flows in the river, and the fish that live in that, the landscape's going to be familiar with higher flows during the winter. And then when it's summer, it's going to be dry, the river's going to drop down lower. Because of how the government has been managing the water across decades, centuries, the reverse happens. So in winter times, they put in dams to block the rivers so they can collect all the water. So in winter time, the rivers run low when they should be high. And then in summer, they want to get the water they've dammed up down to the farms, and so it runs high during summer. So the rivers are running in reverse, and that has huge detrimental impacts on the environment, causes significant erosion. There's the fact that the rivers are not actually able to run slowly means that the fish can't find their habitats appropriately. There's all sorts of things we've seen as a result of that water mismanagement that we are slowly, and in my time in the work I was doing, we're able to bring back some of that traditional knowledge about how to do it better. But there's a long way to go, and that would benefit all of us if we can have our rivers running in a much more appropriate manner back to how they should be running.
And you've mentioned that they're seen as, I think you used the term water delivery vehicles rather than rivers, in the sense that they have a whole range of meaning and roles in the health of the country.
Yeah, they're oftentimes these river waterway systems are sadly just treated as pipes, open pipes, and it completely disregards the cultural connection, the cultural significance of those places, and denies that from all Victorians being able to appreciate that aspect of our amazing country.
I just might ask whether any of the commissioners have any questions in relation to the evidence that we've just heard before we move to the next area. No. Thank you. Thank you. Now, I want to ask you some questions now about the First Peoples Assembly, so that not only the commissioners can hear it, but that other people who are listening to this evidence might understand better the role of the First Peoples Assembly. There were elections in 2023, and as a result of those elections, you, Negara, and Ruben were appointed as co-chairs. There has been some observations made about the voting numbers for that election. Is there anything that you would want to say about the voting numbers at that election?
Yeah, we've tripled the amount of community members that have registered to enrol in our elections, and we've doubled our voters. So we're really pleased after the last election. So we're slowly building that collective support throughout our communities and getting our mob more active and participating in the process.
Now, the membership of the First Peoples Assembly, can you just explain how the membership is comprised?
Yeah, so we're 32 democratically elected members of the First Peoples Assembly. We're quite diverse. We come from 5 different regions across the northwest and northeast, and southwest and southeast, and in the metro. And we're an assembly. We're very unique. We're very culturally strong, and we're building, our Aboriginal democracy within our membership base. And we represent all the communities and traditional owner groups across Victoria. And we've got 11 reserve seat holders that are the registered Aboriginal parties, and we've got 20 plus members that represent the different regions. So that's the kind of composition of the First Peoples Assembly, and we've recently just added an additional seat for the Wamba people.
Is it the case that it can be said that there's any groups who are unrepresented at present?
Yes, there are groups that aren't officially, members of the Assembly, and that's why we initiated the additional pathways process to enable traditional owner groups that aren't recognised formally by the state to take up a seat in the Assembly. So we're really proud of that decision at our last Assembly Chamber meeting, where we voted to bring in the Wamba people to have a rightful seat on the Assembly.
Is there more work that the Assembly needs to do in that regard, or that completes the representation?
No, I think there's more work for us to do, and we're speaking with traditional owner groups that aren't formally recognised by the state, and how they can, take up the process and encourage, traditional owner groups that aren't, recognised by the state, to kind of contact us and follow it up, because it's important that we're inclusive of all peoples that live here. So we've got a bit of work to do, but we have a really strong representation and cultural representation, but we want to build on that. It's not perfect, but we'll keep building on it to strengthen our representation.
So that the intention is to have as full a representation as possible?
I think so, as best to our ability.
Yes.
To be inclusive of all the different traditional owner groups that live here. And we also represent all Aboriginal and Torres Strait Islander people that live in our communities. And that was something that we felt very strongly about throughout the Treaty Commission's process and now ours, around making sure we leave no one behind, and that this is part of a process that we all be part of around our inclusivity. So that's a really big strength that we can bring to the Assembly.
Yeah, and is that a cultural responsibility, do you think, to ensure that nobody's left behind?
Absolutely.
I might just ask Ruben if there's anything that you wanted to add at this point.
No, just that in terms of the actual current membership of the 32, soon to be 33 members, that I think if you looked at all the different groups that they identify as, I think you'd see that all the groups across Victoria are represented in that way. Whilst we still want to continue to pursue, they get a formal recognition with a reserved seat for each of those groups. There is strong inclusion of all groups through the membership of the Assembly as well.
Mr. McAvoy, can I just ask, that's a formal process that if to come to be, sorry, I'm not asking it very well. So there's recognised by the government, and that was how it started, am I correct? And then was that the Assembly's process to bring, so as the Assembly you've created that process?
Yes.
So that you include others and you can bring them along?
That pathway is there for other groups to apply for a seat on the Assembly. And there's a criteria there as well around how that would happen, and we encourage other groups.
And that's an Assembly process, not a government process.
So there's no interference from the government, and that's us having the power to determine how we represent and how we govern, and that's kind of our business. So we're really pleased, to be able to have the first group come forward and be part of activating, their rights to a seat. So we're really happy with the outcome.
Just following on from that point that Commissioner Hunter has raised, it's correct, isn't it, that the Assembly is not a statutory body, but it's a company, and that if I can put it this way, that gives the control of the operations of the First Peoples Assembly of Victoria to the Assembly itself. Is that a correct summation?
That's correct. So we are recognised as the Aboriginal representative body under the treaty legislation, but that's the company that is the First Peoples Assembly of Victoria is the entity recognised as the Aboriginal representative body.
Now, I just want to take you for a moment to something that was raised in the submissions, and that's in relation to the possibility of statewide agreements. And if you, I'd ask you to indicate at this point, has there been any position reached as to who will negotiate statewide agreements in Victoria?
Yeah, so the process we've undertaken to get to this point was to have an agreement with the state around what's called the Treaty Negotiation Framework. And that was the role of the Assembly under the treaty legislation to make sure that there was this Treaty Negotiation Framework. And that set out as part of that agreement that to negotiate statewide treaty, there would be this representative body. And it is, I guess, the presumptive body is the First Peoples Assembly of Victoria. But we have to demonstrate certain things and go through a process that's overseen by the Treaty Authority to actually take up that role of negotiating statewide treaty. So we're still going through that process at the moment, but I would say we're the presumptive body who would negotiate statewide treaty.
And when can that process be commenced, in the sense that the Treaty Authority has been created and there's a statutory arrangement in terms of when those processes can commence? Can you just inform the commissioners of when that is?
Yeah, so there's no fixed time frame of exactly when it has to happen. It's in the hands of the Treaty Authority. They're still doing their preparatory work to get set up to establish what's referred to as the negotiations database. And that's the mechanism by which both statewide level, we would put in an application to say we think we're the appropriate body and meet the standards, but it's the same database that traditional owner groups will also be able to use to enter into. And so that database hasn't been created yet. But once the Treaty Authority does establish that database, we are preparing ourselves to then submit our application. And then there is a 2-month period of comment for community to say how they think we're faring and if they think our proposal of how we're going to go about doing our business is sufficient. And I'm sure we'll get some good responses from community around that. And then we can work with that feedback and then move forward as the body that will negotiate statewide treaty.
Thank you. Any questions on that topic, Commissioner?
Not just to ask, just for general public that's listening, or and for the Commission, so we've got it. What's the easiest explanation for what is the role of the Treaty Authority?
I guess the easiest explanation is they're the umpire for treaty negotiations. We know that if you're going to sit down and have negotiations with two different parties, there's going to be disputes that come up. And it's no good having the person who's going to resolve that dispute being a part of one of those groups that clearly have a conflict. And so the Treaty Authority was established as an independent body that can oversee the negotiations so that if there are disputes, they can help facilitate those. They can make decisions on certain things in the process as well, but the umpire of negotiations.
Thank you. Thanks.
Thank you. For Commissioner Lovett's benefit, we've just been discussing the role of the First Peoples Assembly in relation to the negotiation of a statewide treaty, and if there's any questions you would like to ask, perhaps Commissioner, we can come back to that topic after morning tea. Now, the role of the First Peoples Assembly of Victoria has been set out in the submissions and in previous submissions to this the Europe Justice Commission. Are you able to, in the same way as you've given a very brief summary of the role of the Treaty Authority, give a summary of the role of the First Peoples Assembly?
Sure, happy to. So it's an evolving role. So the Assembly was first established to be the body that would negotiate with the state on the three elements of the broad treaty process. So the treaty negotiation framework, the Treaty Authority, and the Self-Determination Fund. It was the role of the Assembly to negotiate those three aspects. And now we've seen, as a result of that, we're moving towards this next phase where it's going to be the role of the Assembly to actually negotiate statewide treaty outcomes. And through that, we've already identified that our aspirations are that as a result of that, we would then aspire to be a body that would then be able to hold powers as a result of statewide treaty outcomes. So we really see it in three phases. There was the first phase about negotiating the process. The second phase is then actually negotiating treaties. And the third phase is actually exercising powers that we hold as a result of treaty.
Mm. And as the First Peoples Assembly of Victoria is a representative body, how important is it that the First Peoples communities in Victoria are brought along with the process, if you know what I mean?
Yeah, it's really important. And that's always in the forefront of our minds, that mobilisation and organising we need to do with our mob. And I think with our election numbers double tripling, which was a fantastic result, to have more collective support and to slowly build that consensus that we need across the community. So we've got more and more people involved and active in the process and contributing in many different ways. So it's really important that they're on this journey with us. And I think that we've built that momentum as we lead up to treaty negotiations, and we've still got a lot of time to still have those conversations with the mob and what are their kind of priorities and aspirations for a statewide treaty, because there'll be many treaties. There'll be a hybrid approach, so we'll have a statewide treaty to cover statewide matters, and there'll be traditional owner treaties, and that'll be the business of the traditional owner groups, and they'll have their own aspirations on their own country, but there'll be many treaties to come.
Thank you. So with respect to the possibility of a third phase, that's the intention to have a third phase, Um, it may be too early to discuss what that might look like now, but is that third phase of representation and holding power something that would form part of the statewide treaty negotiations?
Yeah, absolutely. That's the intention. That's what we're working with our community to understand what our, I guess, our negotiation brief is going to be, what it is that we want to bring to the table, and those ideas around seeing the Assembly evolve into a body that can actually exercise decision-making powers, can provide critical advice to government, can hold government accountable for its actions. Those are the things we're looking at aspiring to as part of those negotiations. But as we know, that's all going to be part of negotiations with the state. But that's where we're establishing our position of what we're aspiring to as a representation of what we heard from community and where we think is the best place to go from an Assembly perspective.
This commission will be hearing from the Minister for Treaty tomorrow. The First Peoples Assembly of Victoria's engagement with the Minister and the Department in relation to the types of vision that you've explained to this Commission today, has it been an open and a good exchange, or is there room for improvement?
I would say there's always going to be room for improvement, but from my experience, there's been a very good, positive conversation so far about what our aspirations are. And yeah, I'm looking forward to when we actually can start to sit down and have those negotiations.
Are there any elements of the treaty process or the First Peoples Assembly that you're able to talk to the Commission about today, bearing in mind that the statewide negotiations are yet to occur, as to how you might future-proof the process and the Assembly?
Yeah, we're very mindful of the need to make sure that we can future-proof it, and this is again one of the learnings we've seen from other countries where they have had treaties in place and agreements in place, and some of those have been able to endure, and we see attempts still today to try and unwind some of those. So it is something we are very mindful of, and I think from my perspective, very mindful of not putting all our eggs in one particular basket. I think it's going to be a case of thinking of a multitude of different ways that we can make sure that we can have that sense of future-proofing, whether that's through legislation, whether it's through other forms of reform, but also from a cultural sense that we want to see the Assembly as a body that not just First Peoples embrace, but that all Victorians embrace and see the benefits of having this democratically elected group of First Peoples, so that there is that sense that this is something that's a part of Victoria and an enduring part of Victoria. And I think if we can have those conversations, then I have great confidence in the future-proofing of what we're trying to achieve. One of
the questions that arise in that regard, in terms of bringing the whole of the state along with you, is the position taken by the opposition following the voice referendum last year. Is that something that you have hopes will be able to change over time?
You go. Yeah, that was disappointing to have the opposition withdraw their support, but our doors are always open to discuss treaty with all sides of politics, and that's something that we'll continue to do, is to meet with all sides of politics. But we've got a government committed, and there's law binding us to do treaty, and we'll do that within this term.
Anything you would like to add, Ruben?
Yeah, I guess I'd just add that oftentimes a critical part of the conversation in the broader community is around the closing the gap conversation. And sadly, that's often a deficit-based approach. But I think you look at the statistics and you recognise there is a discrepancy between outcomes of First Peoples and outcomes of the broader community. And I think that all Australians, all Victorians want to see that close. Like, nobody wants to live in a country where one particular group of people have that huge a discrepancy than another group of people. And so there's often lots of discussions about how you get to do that. And we saw from the Productivity Commission most recently saying that the ways that we're currently working towards closing the gap aren't getting the results we need to see, and that the key changes we need to see if we do want to go about closing the gap are around greater decision-making powers being transferred to First Peoples and greater accountability of government in actually delivering on the things they're supposed to be. And those are the very things we're striving for towards treaty. So if there are segments of the community that think that closing the gap is the way forward, well, the treaty is actually the mechanism to help us close that gap.
One of the offshoots of that discussion is, of course, the achievement of some level of funding security for the process. Do you have any insight that you can give the commissioners as to the Assembly's view about how funding security might be achieved?
I think at this stage, we're still looking at all the different options that might be possible for us to want to bring to the table, but that will be a key part of the negotiations to make sure that we're not establishing this future body with a sense that there's it's at the risk of government just being able to cut off the funding and then it withers away on the vine. We're very mindful of making sure that as part of our negotiations, a fundamental part of that will be ensuring that there's some security around the funding for such a body, because without that, it won't be able to succeed.
There is in the Advancing the Treaty for Aboriginal Victorians Act, the creation of a self-determination fund. Can you just explain for the commissioners what that fund does?
Yeah, happy to. So the self-determination fund is a really critical part of the treaty landscape, so to speak. And it's been set up with two key priorities. The first priority is to make sure that traditional owner groups who do want to come to the table and negotiate their own treaties actually have the resources to be able to do that properly. Because we know that if you go and sit down to try and negotiate and one side of the table has all the resources and you've got barely any, that's not a fair negotiation. So the fund is there overseen by First Peoples. The state has no role to play in how that fund operates. It's completely in the hands of the Assembly and then the fund that we established. So that primary purpose at the moment is to support traditional owner groups to have the resources they need. And there's a very broad scope about what that might mean for traditional owner groups. So if traditional owner groups think they need resources to do research, if they need resources to actually bring community together, if they need resources to have conversations with their neighbours, if they need resources to get legal advice, there's broad scope for things that are going to fit within that broad umbrella of getting them treaty ready. But the longer term purpose, and one that I think for myself I'm particularly excited by, is the longer term purpose is to have a pool of resources to enable us to build wealth and prosperity within our communities. And I think it's a fundamental reality of how our system works is that when you have funds, you can generate more funds. When you have resources, you can leverage that to generate more resources. And the sad reality is that as a result of colonisation, so many of our people are without that base level of resources to be able to build from. And so the Self-Determination Fund second purpose is really going to be an element that enables us to invest in our own communities, to invest in our own people, our own ideas, to generate that wealth and to input into the broader economy by doing so.
So is it the case that identifying how the Self-Determination Fund might be put to the governance and support of organisations, in particular First Peoples Assembly, is part of the funding security, or is it the case that there needs to be some other account that's created for that purpose?
Yeah, I think that's probably an ongoing discussion. I would like to think that the resourcing for a future version of the Assembly is separate from what needs to be done with the fund, because we want to make sure that that fund is there to just benefit community and that there's a separate stream to actually make sure that the Assembly has longevity and that future proofing. But that's still an ongoing part of the discussions we'll need to have.
Now, the terms of reference for this Commission of Inquiry include making of some recommendations with respect to redress. If that redress were to include monetary compensation, is the Assembly's view that monetary compensation would go into one of those two accounts that we've just discussed, or is that a further account, or is it something that you haven't settled on yet?
Yeah, I think we haven't settled on it as yet, and obviously that will be part of our negotiations. And no amount of money, and I don't want to tally it up either, can compensate the pain and suffering that our people have felt. But that will be a discussion for negotiations, and it's a sure bet that that'll be part of our treaty negotiations. And the Self-Determination Fund is well equipped to go into the future, and it's First Peoples led, so it would be, in a good position, as Ruben said, to take on funds and to also build that prosperity and wealth well into the future.
Is there anything that you would wish to add?
Yeah, I guess I just to add to it that as Nagara said, there's no particular amount of funds that can undo what's happened in the past, but I'd much rather be future focused on what can we do to make sure that future generations aren't left behind like the previous generations have been, that we can build that wealth and prosperity for our communities. And that brings, as I said, as this whole process is about, that brings benefits to First Peoples, but also then has flow-on effects to benefits for all Victorians.
I might just pause there for a moment, Commissioners, to ask whether there are any questions in relation to the material that we've just covered. Now, the treaty authority has been established, as we've discussed. There have been members appointed to the treaty authority. Did the Assembly have a role with government in that appointment, or is it a matter for the Minister?
It was a really interesting part of the negotiation process around how that treaty authority would be established. And so their independence was really critical. And so there was a slightly convoluted process, but there was a process established for the appointment of those 5 members, in that a panel was established, and this panel was appointed by both the Assembly and the state. So there was a degree of separation. So the Assembly was able to choose one representative for that panel, the state chose one representative for that panel, and then there was jointly agreed on 3 other members of that panel. So that 5-person panel, they went away and they ran a process to select the treaty authority members, and their decision on who they selected was we were required to then endorse that as the members of the treaty authority. So that enabled it to have some level of input on the panel from the Assembly and the state, but then they had that role. And I think it's an interesting phased approach that in all the conversations we're having with the state around how we keep moving that dial towards greater self-determination. And I don't think it's going to be something that happens just overnight. It's an ongoing process, but that was another positive example of you could have had it that, yes, it was just the minister was going to appoint those treaty authority members. That could be a way that in other jurisdictions, perhaps that would have been the default, but we're able to advocate and have that strong push that, no, this needs to be moving the dial towards self-determination, so that joint selection of a panel and then leaving that panel to entirely have the decision about who that authority was, it was a really powerful element, and slowly shifting that dial, transitioning the state to think differently about self-determination.
So can the Commissioners take it from that discussion about the appointment of the members of the treaty authority that the Assembly sees that process as a robust process that is consistent with the notion of participation in the business of government in a equal manner?
Yeah, I would say so. I think it's definitely a strong way along that path, and it's an evolving process. And often I have these sorts of conversations with government agencies and government officials, and I think there can sadly sometimes be a tendency to kind of rest on your laurels. That, oh yeah, we've put in this great plan that talks about self-determination, which, as we've seen from some of the work through Uruk, doesn't always actually mean self-determination. But there can be a tendency for government to think, oh, we've done that. Now that's the new standard. That's all we have to live up to. And I'm always of the mindset that we have to keep shifting that dial, that yes, that way the treaty authority appointed was really good, but the next phase, we might move to even stronger element of self-determination. There might be a time where there are positions within the state that the government might not have a role in deciding. It should be up to First Peoples to appoint First Peoples representatives for various roles. So it's about continuing to make sure that government isn't resting on its laurels and pushing the boundaries of what is where we think self-determination should be headed.
Yes. Thank you. I just want to ask you now a question about the relationship between statewide treaties and First Nations treaties. Obviously, this is still down the track some way, but is it envisaged that the statewide treaties would be binding on the First Nations or First Peoples groups in Victoria?
As I mentioned before, it'll be a hybrid approach. So the statewide treaty, will cover statewide matters, and obviously that will affect traditional owner groups across their countries. So there's that connect that we have, having reserve seat holders, for example, on our assembly, to be able to feed into the statewide process, and that's all part of our engagement with community as to what they want to see in a statewide treaty, and we're having those conversations with traditional owner groups and communities from the different regions. And then the traditional owners will do their own treaties, and that'll be their business, and the context of their treaties will be, what they'll determine and at their kind of discretion of what they want to treaty on. So there will be many treaties, but there'll be things where we'll look at removing some of the barriers through the statewide treaty asks that will probably, help traditional owner groups to achieve their aspirations where legislation has failed, or, programs and policies on their country. They'll have their own aspirations around health, education, health, education, housing and justice. So we'll look at that, at a statewide level where we're talking to the community control sector that kind of cover the health, education, housing and justice thematic areas. So there's definitely a connect between that. But the traditional owner treaties, that'll be their business to how they do their treaties on their country.
So you don't see the statewide agreements, statewide treaties as having an effect on the exercise or a negotiation of rights by individual First Nations in their own First Nations treaties later on.
Yeah, that's correct. So as an example of, and just as a hypothetical about some of the scenarios we might be looking at a statewide level, it's possible that we might bring to the table the idea that through education, there should be the capacity for traditional owner groups to teach their language at schools within their area. Now, that might be an agreement that's reached at a statewide level to apply to all parts of Victoria, but it would be up to the traditional owner groups at a local level to decide if they wanted to exercise that right to have their language taught at those schools. So it wouldn't be imposed upon traditional owners at that level. It would be open up possibilities that they could choose to exercise. But at that level between the traditional owner groups and the statewide treaty, there's possibly going to be conversations that need to happen. And that's another role of the treaty authority, is to actually oversee those types of discussions. If there is some complexities around what that overlap might look like between statewide treaties and traditional owner treaties, that's a role of the treaty authority to support that. And neither of those types of treaty is seen within the framework as have priority over another.
So that in that scenario, if a First Nation were not putting a position that it wasn't represented by the First Peoples Assembly of Victoria and in effect disown any statewide agreement, that would be a matter for them, and they could go off and negotiate their own treaty if they wanted to? Or would the statewide treaty be binding on them in that sense?
So there would be matters that are for negotiation for statewide treaty that a local group who might not necessarily agree with that couldn't necessarily leverage that through their own treaty making. But we would try and address that through our approach to when we reach agreement on treaty making, regardless of who's at the table of the 32 or 33 members, we have a requirement under the framework to seek collective support of any agreement we reach. Now, that doesn't mean necessarily that every single first person in the state's going to agree with the outcome, but we have an obligation to have that process to seek collective support and try and make sure we are bringing along community. So it was through that mechanism their concerns could be raised and understood, but that wouldn't necessarily mean they could then go and negotiate a separate statewide treaty outcome, but they'd be free to negotiate at a local level outcomes that they desired.
Thank you for explaining that. Commissioners, are there any questions in relation to that last series of questions?
You may not be able to answer this because you haven't really not negotiating it. But we're talking about traditional owners, and I'm just wondering where the organisations fit in, because that could be with traditional owners or it might not be. And so if we're talking about service delivery in the areas or the regions, sorry, in my head I can understand what I'm saying. So if there was an org that had a delivery service, say on Wurundjeri, on my country, and Wurundjeri were negotiating, their own treaty, would they still have the option to negotiate with the service delivery provider, or does the organisation sit at a statewide level? Does that make sense?
Yep.
Yeah.
Yeah, that's one of the complexities I think we still need to work through. But there is the scope under the framework we've established. There's the scope to not just have the traditional owner group and the state, or the assembly and the state. There's the scope to bring additional parties to the table. So it could well be that a traditional owner group said, we want to come and negotiate treaty and we want to bring this other organisation in to be part of the negotiations. That's on the table. We've been really mindful through this whole process to make it flexible so that there is that capacity for different scenarios to play out. But there will be interesting ongoing discussions between local traditional owner groups and Aboriginal community controlled organisations in that space. And there's a requirement through the minimum standards that all parties who are coming to the table have a process to consult with relevant groups within their areas. So that'll all feed into those conversations.
Great. Thank you.
We are scheduled to have morning tea at 11:30, Commissioners. I might just ask one further question of the witnesses before we break. After morning tea, I propose to take you to some recommended findings that are contained in the First Peoples Assembly of Victoria submissions. But before we go there, is the role of the Commonwealth in entering agreements such as statewide treaties something that you've considered and have a view about whether it would be beneficial or not to have the Commonwealth present for those negotiations?
Yep. So the way that the framework's established, the Commonwealth can be an additional party to treaties. So there'll be definitely jurisdictions within the traditional owner groups that can consider their relationships, because they'll have agreements currently with the Commonwealth and with the state. And they'll also look at treaties across councils, like Wurundjeri, for example, will have a number of councils across your jurisdiction. So there's definitely an opportunity and something that we've spoke to the Commonwealth about at some stage. Parties will be invited to treaty with the different groups and at a statewide level as well.
Certainly in the context that there's a significant involvement from the Commonwealth in the Close the Gap funding and national agreement, it would seem to be important that for statewide agreements, there are many areas that their involvement might be needed at the table. Would you agree with that proposition?
That's something that we've considered, and working with the Gunditjmara Closing the Gap Koori Caucus around their current arrangement and what that will look like heading into a treaty era and the future of treaties at the statewide, but also at the Commonwealth level.
Thank you. If that's a convenient moment, Commissioners, to take the morning tea adjournment, what time should we return?
How long do you think? 15 minutes? 20?
Perhaps 20?
20 minutes? All right.
So at 10 to 12?
Yep.
11:50. Thank you.
Thanks, everyone. York Justice Commission is now resumed.
Thank you, Commissioners. I now wish to take the witnesses to the submissions to the York Justice Commission in relation to land injustice dated 22nd of December 2023. That document will be in the Commissioner's bundle. On page 33 of that submission, there's a number of findings that the Assembly asks the Europe Justice Commission to find. And I just propose to explore those a little bit. Firstly, summarising the first finding, is it fair to say that that finding, the proposed finding that issue-specific law reform in systems affecting land justice is not enough to address systemic injustices faced by First Peoples? A whole-of-system approach to land justice gives effect to genuine self-determination should be negotiated through the treaty process, which addresses matters that include the return of land, redress, public land and water management, commercial use of natural resources and cultural heritage protection. Is it fair to characterise that request as one which places the ownership of land and water and resources at the centre of the need for justice in relation to the treaty process, or is it not that central?
Definitely central to the traditional owner treaties, and that'll be what they'll look at and consider around reform in regards to their country, but we'll look at barriers that we can remove around specific law reform. And there's a lot of issues that we hear from traditional owners and community, and we shouldn't wait just for treaty to activate it. It can be done now. And we hear that, from our mob, and we look at different reviews that have been done and reports over the years that have just sat on shelves in regards to the Aboriginal Heritage Act, for example. The Heritage Council have done a review, which none of those recommendations had been implemented. And that's something that, we can call on to do now.
But there are a number of urgent reforms that have been identified in this submission, which I'll come to. But in terms of the delivery, if I can put it that way, by government of ownership of land and water and resources, it's fair to say that there's much yet still to do. That wouldn't be an understatement, would it?
No, I definitely agree that there's much more to be done, and I need to recognise that it's a complicated, nuanced conversation that will take considered time for us to know what our position is, and hopefully drawing from what York is hearing from the broader community, that will give a good, strong sense of what community's aspirations are in this space. And then that will then feed into what the negotiating position will be. And then that's then an added complexity of having to sit down with the state and negotiate what might be possible. But at the forefront of our minds will always be that we need to make sure that wherever possible, there is the capacity for First Peoples to make decisions about First Peoples matters, whether that's to do with land and waters or heritage, or the broader areas that we're also interested in around education, health, all those other factors.
But I'll put this to you, that it's possible, perhaps probable, that the existing mechanisms will not deliver enough land for the needs of some groups in Victoria. Would you agree with that?
I'd agree with that. I think we've seen the current systems that are in place are not adequate to address the impacts that we're seeing, and what the mechanisms might look like to address that. I think that's what we're hoping to hear from as part of this process. I don't know if there's a fixed idea of what that looks like, but absolutely, business as usual is not going to deliver the necessary changes.
So by business as usual, in the land space, I suppose we're talking about the Native Title Act and the Traditional Owner Settlement Act. That's business as usual.
That's absolutely definitely part of that. Yeah.
And in the water space, there is very limited capacity for ownership and control of resources. You would agree with that?
I would agree with that, because that brings in complexities of Commonwealth and state, and there's a whole lot of jurisdictional issues there. But that doesn't mean that there's not change that can happen in that space if there's a willingness to do so.
Is it appropriate to say that in terms of public land and water management, that there's much more that needs to be done?
Absolutely so. I think we've seen joint management in lots of places as outcomes, but I think we need to be looking at opportunities to look for sole management by First Peoples of some of these matters. And within the water space, I know there's aspirations around that, but a lot of times there's legislative blockers that make that difficult. And I see treaty as a really powerful opportunity to kind of open up some of those blockages within other pieces of legislation to enable greater capacity for First Peoples to have influence and decision making over land management and water management in particular.
And the capacity to have very focused discussions about those things, you expect that to come through the treaty process. You haven't been able to have those discussions in the same way in the past. Is that a fair observation?
Yeah, I think the treaty landscape, the intention of it is to open up a different relationship between the state and First Peoples, whether that's at a statewide level or at a traditional owner level, one that recognises the inherent rights of First Peoples as part of that conversation. And so I think through that lens, that will enable greater traction on outcomes that we haven't been able to see previously.
Have there been particular difficulties with obtaining recognition of the rights of First Peoples to engage in commercial use of resources? Is that something that you hear about or are aware of?
Yeah, particularly in the water space, that's an issue. And we often talk about in the water space this concept of cultural flows. And we know that there's significant work being done around environmental water, but environmental water can only be used for particular purposes. Now, oftentimes that purpose of using that environmental water aligns with the interests of First Peoples, because it's often about making the rivers better, making the wetlands better through the use of water. And so there often is strong alignment between that, but that can only go so far to the aspirations of First Peoples around water. And it doesn't enable the use of water for commercial purposes, for aquaculture purposes, for those sorts of expanded things. So that's definitely an ongoing issue, and one that will be able to be, hopefully, will be put on the table as part of treaty to progress that element of cultural flows, whereby First Peoples are able to access water and utilise it not just to benefit the landscape more broadly, but to actually achieve broader cultural aspirations and economic aspirations.
The economic component is an important component in the overall package then?
Absolutely. I think what we're trying to make sure is that there's opportunities for First Peoples to partake in the economy, an opportunity that's been denied for generations of our people to participate in the same way as other members of the community. And that hasn't just been to the detriment of First Peoples, that's been to the detriment of all Victorians. When you have one segment of the community unable to participate in the economy, that actually is a detriment to everybody. And so by enabling through this process greater participation and activation of First Peoples in the economy, that brings broader benefits quite clearly to the broader community, especially at a regional level. When we can strengthen regional communities through traditional owner groups, I think that we'll see, and we have seen already demonstrations of that, but that will only be enhanced through treaty discussions.
Can I ask both of you, what does water mean for our people?
Well, from my perspective, water is life. It's the giver of life across our countries, and it's the very veins of our country. through all our traditional owner groups, through the rivers, the creeks, the waterways, the waterholes. So it means a lot to us. And I think in times that people have played God with our water. So there's definitely an opportunity. I know, the work that the Gunai Kurnai do around water rights and activating their rights in that space is, vital to our survival and, to heal our country.
Yeah, and I think about Fenyang Puna, the Hopkins Falls, as being such an important cultural and spiritual place for my family across generations. And oftentimes it's funny going and visit. I visit there every time I go down to Fram, and you see so many people come to the falls there and just are kind of passive observers of it and just kind of stand there and take a few photos and then leave. And I'm always very keen when I'm there with my family. We take our shoes off, we go down, we get in it, we actually be part of that landscape. It's not just a passive thing to observe. It's an inherent part of who we are, engaging with those waterways.
Following on from that question and your previous comments, Ruben, about the cultural heritage legislation reforms, the protection of cultural heritage in Victoria is an ongoing area of concern for First Peoples, to put it mildly. Is it a matter of particular concern that the reform process is taking as long as it has?
Yeah, absolutely. So I think there has been identified in that cultural heritage space, there are some significant improvements that could be made and would lead to positive benefits. And that came from a really strong work to engage with traditional owners and the community about what they thought needed to change in that space. And I know that for me personally, so as well as being involved in water, I was also involved with the Heritage Council of Victoria. And I saw the stark contrast between how a non-Aboriginal cultural heritage was looked after and protected as distinct from the way Aboriginal cultural heritage was. And it was a significant contrast between that. And I think that it is useful to have a different system and important to have a different system for Aboriginal cultural heritage. But the lack of capacity to elevate some of our cultural heritage to be of statewide significance and treat it with the same care and diligence that the non-Aboriginal cultural heritage gets treated is a significant gap, I think, in my mind, about how Aboriginal cultural heritage is respected and treated within this state.
Does that go to a much deeper issue about the respect for First Peoples culture?
Yeah, absolutely. And I think oftentimes it stems to a lack of imagination, I think, on people's behalves. That in my time working in the heritage space, there was often a strong focus on those tangible things that you could see, the very same wallpaper that was there from the 1850s. And so that enabled people to say, yes, this is important heritage. Whereas when there was an open space that just contained stories and memories, people didn't have the imagination to say, well, this is equally important as this, and I would say far more important than this wallpaper that was from the 1850s. So lots of times it's just a lack of capacity to step into the shoes of First Peoples and have that sense of there are stories connected to these places that have been passed down from generation upon generation upon generation and still being told today. And that's not just an important part of First Peoples heritage. That should be an important part of all Victorians' heritage, to embrace that and celebrate that. And it just takes stepping out of that mindset sometimes and putting on that perspective of what might this be from an Aboriginal perspective, and to be able to then really value that in the same way that we do as First Peoples.
Thank you. The recommended finding number 1 suggests that each of those matters that we've discussed, including redress, should be dealt with in a whole of system approach. And I'm wondering whether it's envisaged that the statewide treaty process will lay the framework for that level of reform. Is that what's envisaged, or a different process?
Yeah, so it is complicated because we have to factor in that there are some of these rights that we're talking about there are related to traditional owner rights that they might want to be negotiating at a local level, as well as have an influence on the statewide treaty negotiations. But I think what's critical from my perspective around that is that it's no good just going, okay, let's just go and focus on land. And then when we finish thinking about land, let's go and think about water. And then when we finish looking at water, let's go and look at heritage. It needs to be thought of as an entire system in how we approach it. Doesn't mean there's one solution to it, but it means that you can't look at it in isolation. They need to be looked at as part of a whole in how we're tackling this through that treaty landscape.
And in treating it as a whole, is that consistent with First Peoples' views about managing the landscape and taking a more holistic approach to looking after country?
I think it is, and it's all interconnected. That's how we view the Aboriginal cosmos, and that is all connected from land and water and people. So, yeah, I think it aligns to that thinking.
I might ask you to just have a look at the second the second recommendation from the Assembly to Europe, that mechanisms that shift decision-making power from government to First Peoples to give to effect to self-determination in caring for country should be progressed through the treaty process. Is it intended that decision-making power, the shift of that decision-making power, be dealt with in the same whole of system approach that is referred to in the first finding, or is that something that can be dealt with separately?
Before we get to that, sorry to jump in, but I just wanted to ask a pre-question to that, which is, and I'd like you both to answer this, what does treaty mean to you, mob, as individuals? And then the secondary question is also about the importance of a shared future. And then we go into the decision-making stuff and so forth. But what's the importance of treaty to you, mob?
From my perspective, I think treaty will really heal and empower our people. It's about resetting relationships. We've come from a history of colonisation and injustices and atrocities, and we've come from a part of this country where it's been built on a lie. So I think that's where Europe have a really powerful role in changing the narrative and sharing our stories more broadly across the community here within Victoria. I think that treaty is really about shifting that power in relation to our affairs and our matters. So we know our community best, so it's us that will determine our future and our destiny and how our people live out their livelihoods on their countries. And I think that's a big shift that we're looking at around that transformational change that we're seeking through a statewide treaty negotiation and a body to have that power and decision-making powers and the resources to do that, and shifting that out of the state's hands and putting that power and responsibility back into our people's hands. And it will happen on a statewide level, but traditional owners will have their aspirations for treaty. But I truly believe that treaty is our future. We've come from a history where we've come off the missions and reserves. We've gone through an era of our advocacy and fighting for our rights through the 70s and 80s. We've come from the community control sector into this space, and everything that we've done has prepared us for us to now shift into a treaty era. And I think that's going to be hard to change those mindsets, but we're literally collecting people one by one to build that support and consensus and a future where we are strong and healthy and balanced on our country, and that everyone in this community thrives, into the future. And, I can't emphasize enough how we don't have any land. We don't own any land. And it's the land that we do have, it's a speck on the map. So I can't articulate that enough to what that means to us. And land is integral to the sovereign concept. So we need to have our land back at times where we're going to have to be able to practice our culture and restore our families and communities onto our country. And, we have culture and language and we have all these things that we've got to get to, and we just want to move on with our lives. I think we get so caught up in the trauma and the pain and the suffering. We're the most traumatized people. But how do we shift that for the future for our children and our vision around what a treaty era looks like? And it's going to be forever now, because once we start doing treaties, it's just going to be part of our lives, and we've got to start thinking like that. And it's for the future generations. It's going to take time too, because we've got a lot of healing to do. I think Europe will support that healing that we need for our people, and we've got to mobilise and organise. Like, we have to form treaty delegations, so our people got to come together. And despite all our differences and the disputes that legislation has caused, the harm, when you look at Uncle Graham's talk about the Yorta Yorta case and the harm and trauma that we've carried, you know, we've got a lot of work to do around our healing and coming together, but I think that treaty will be that vehicle to get us to where we need to go, and we've really got to start to come together and work out our aspirations and how we want to build our nations and empower our mob, you know, as we go forward. So yeah, that's kind of, it's hard because treaty means so much to different people and different perspectives and interpretations of it. But I think if we've all got that vision, and that's one thing with the Assembly, we're very diverse, have very different opinions, but we're all there for the goal of treaties for our future. That's one thing that we all agree on. So we've found that common ground, and it's just how we get there now. So I think, yeah, we've all got a responsibility and a role to play in getting us there and to get us over the line in these first negotiations. What about you?
Treaty to me means a future where our communities are thriving and our cultures are at the heart of our daily lives. That's what it means to me.
And when that can happen, how does that benefit all Victorians and all Australians? Do you want to comment on that?
Yeah, as I've said previously, that when our communities are thriving, that brings benefits to the broader community, especially in regional settings, to see our strong traditional owners groups and our Aboriginal community controlled sectors out in the regions, when they're thriving, that brings benefits to those regional communities. And when our cultures are at the heart of our daily lives, that just won't be at the heart of daily lives for First Peoples. That will mean it's a centred part of all Victorians, that they can have this sense of pride in connecting to the more than 60,000 years of culture and engaging with that, not as some other, as we still too often see, but to be able to engage with it as something they can connect to and have a sense of pride in, even though it's inherently still something that belongs to First Peoples. They can still take pride in that and celebrate that. And that will be, I think, a future that benefits everybody.
Thank you, Council.
Just following on from Commissioner Lovett's questions, I might start with you first, Ruben. Are we to take it from your answer that you see that there is some healing to be done on the non-First Peoples side of the equation as well, and that treaties might assist in that?
Absolutely. I think if you were to just look at treaty and say this is something that's just a useful tool for First Peoples, I think that's a misunderstanding of what treaty is. Treaty is an opportunity to reset the relationship between First Peoples and non-First Peoples here in Victoria, and for them to be able to help reconcile with some of those things that have happened in the past. And that's why this York process is so critical, to enable the broader community to understand what that past is, and then through treaty to give a tool to be able to reconcile with that.
And Nagara, you mentioned the trauma of First Peoples' existence, and you referred to the evidence that the Commissioners heard only 2 days ago from Uncle Graham Atkinson about the trauma attendant on the Yorta Yorta decision. When people think about trauma to First Peoples, often they think about it as being something that happened in the 19th century, or is something that happened in the past. But is it something that people is it the case that First Peoples in Victoria are still experiencing trauma from the way the system operates?
Yeah, I think so. And even with York and the inquiry around the criminal justice system and child protection system, identified that trauma and the system is broken. As a Yorta Yorta woman, like the example of the Yorta Yorta case has been detrimental to our people, and we're still suffering the consequences of that case. And I think Uncle Graham talked about that. It's in our psyche now, and something that we've carried over generations. And I can't emphasise enough about how much harm that caused our people, I think, with all the division that it caused within our tribe. So the historical tensions have carried over generations. So yeah, we still feel the impacts of colonisation today and the systems that have been imposed on us. And we're unravelling a really complex system of legislations and policies, structures and process, and we're trying to decolonise the way that we think. And I think that we're often imposed with these white constructs. And yeah, that case was quite significant to us, and a real kick in the guts. So I think our people, our elders still feel that today, and it has caused a lot of disharmony across our community. So it's something that is really raw still after all this time. So yeah, as a Yorta woman, as I said, like, it's still something that we're dealing with today.
And do you see then as treaty as a way in which the continued trauma might come to an end?
Yeah, I think that the Treaty Authority is a good example of that, and what we were thinking around the establishment of that and removing the government out of our space to stop interfering in our business, because we've had to settle, native title and, via the TOSA and agreements that we've done in the courts, and it's created a lot of litigation right across the state. And that's something that has affected our people because they're in the courts, and that's how they've been dealing with it. But the Treaty Authority will be that independent umpire to culturally have perspective to how they'll bring people together around their treaty delegations, and they'll have to mediate and settle some of the disputes, but it'll be our way. It's on our terms, our business, and they'll have those culturally strong foundations to come from because they are independent. It's an Aboriginal-led Treaty Authority. So I think they'll have a big role to play in bringing groups together to form their treaty delegations. And I think that treaty, there'll be things that we'll settle through our own business and remove, the government influence out of the space, because at times it's just been set up to divide us, to pit us against each other, and it hasn't been constructive or productive for our people. So I think that's where we're calling for self-determination or self-government to manage our own affairs. That's all going to be considered and part of our treaty negotiations, and our people will have many aspirations and dreams and hopes that they'll want to put into this around their future, and they're thinking around, how they want to coexist.
You've mentioned with some pride your daughter being a treaty kid. Is there some hope that your daughter's generation, the next generation, might be protected from the trauma that perhaps your forebears and yourself have experienced through the treaty process?
Yeah, I hope so. Like, I don't want to hand down that to my children, and I think we're all preparing our children, Aboriginal and non-Aboriginal kids that we have in our space with the treaty work that we do, and that's all they know. They've just kind of lived and breathed it for the last few years throughout our term, and I hope that when they grow up, treaties just are given for them, and that's just going to be part of their lives. So we're starting to prepare kids around that, and I think that's where there's a big role for Yorta around the public education piece that we need to look at, and what stories we tell our kids, and that we will be in a treaty era that we're in now, and how we'll go forward. So I hope that all our kids and families, grandkids, they'll all be part of it, Aboriginal and non-Aboriginal. It's about all of us, coming together to work out how we're going to go into the future.
Ruben, you've referred to your hope that your people will be thriving, and we understand from that would mean not subjected to traumatic events delivered by the system that is the dominant system in the state.
Yep, absolutely.
I just wanted to move on to the recommendation number 3 from the submissions on page 33, and that's regarding the redress formula. You've talked about the self-determination fund, and you've talked about how economic self-determination is important to the exercise of self-determination generally. is it correct to say that that these, well, I'll withdraw that and put it a different way. Is there any discussion within the Assembly as to the mechanisms by which the state might deal with future redress?
No, not at this stage. That's still an ongoing part of our considerations, and that will form part of our what we'll see as part of our negotiation approach once we consider that from our perspective.
If the state were to start setting aside funds now into an account to prepare itself for its redress obligations, is that something that it would be consistent with the view of the Assembly?
Yeah, I would say so, that if that's a consideration they wanted to make.
Of course, there would be issues in relation to how that fund was controlled and managed and where it sat in the scheme of things, but certainly having money set aside in advance for the treaty discussions takes some of the difficulty out of the negotiations. Would you agree with that?
Yeah, I mean, I'd say so. So as we've said before, the Self-Determination Fund has that broader aspiration around building wealth and prosperity for our communities. And so I would see that aligning with some of those future aspirations, and the capacity to have a fund that is completely controlled by First Peoples for that purpose of benefiting First Peoples is a strong model to be able to move forward with, depending on outcomes of treaty negotiations.
So from that finding that you've recommended, the Assembly has recommended at number 3 of the recommendation, it's suggested that there might be a formula that's created which would then assist in understanding what the future liabilities might be. And is that, have I understood that correctly?
Yeah, I think wherever possible in this space, it can be useful. And I think at times Victoria is very strong at saying we're at the forefront of this. We're the leaders in the nation of this and that, and that's many Victorians take great pride in that. But at times I think it's also beneficial to be able to step back and look at things from a global scale and recognise that these sorts of conversations have already happened in other jurisdictions around the globe, and there's no need to necessarily reinvent the wheel from scratch. That if there are applied standards that have been used in other jurisdictions, it makes the most sense to draw from that and to give greater comfort, I think, to the broader community that these are not, outlandish things that are being considered. These are things that sit within the context of a standard way of approaching these sorts of considerations from a global perspective. So it's that balance, I think, at times of Victorians being very proud of how on cutting edge we are, but also realising that in some things there's already a precedent been set and we can draw from that to give us comfort that we're going about things in a considered and appropriate way.
Another way of putting it might be that the bar is fairly low in Australia to start with.
I'd agree.
A couple of the issues that have been identified in relation to the redress formula include the calculation of interest, and we saw that as an important part of some recent High Court litigation in relation to Timber Creek. That is not an unusual part of a redress calculation, and I wouldn't expect that you would see that as being something exceptional. No,
and with treaty negotiations, nothing's off the table, so this will all be considered in our discussions leading up to negotiations, and something that we discuss within the chamber across our membership.
The 5th dot point refers to the redress formula not being limited to the colonial constraints of the Native Title Act. That would be the restriction that arises under the Native Title Act for states' liability for past acts back to 1975, but not beyond. That's what is intended by that particular dot point.
Yeah, I think the overall intention is that as part of this this process that Yuruk looks at all the different mechanisms that might be appropriate to bring that to the table, so that that's a tool that the Assembly can use as part of its negotiation. So absolutely wanting to make sure that as through this process, Yuruk is considering the full breadth of what might be possible and what might be the most appropriate measure to move forward with.
Do we also take it from that the Assembly sees the redress formula as taking into account considerations beyond land and water and the things that might be captured by the Native Title Act? So
That would all be considered.
the last dot point on finding number 3 is that it should be informed by and consistent with the United Nations Declaration of the Rights of Indigenous Peoples, and particularly Article 28. And so is that intended to say to the Yuruk commissioners and the government that there's an international context to the way in which this formula ought to be reached?
Yeah, absolutely.
The final part of the redress formula, a discussion in this recommended finding, refers to building on and strengthening the principles previously recommended by the First Principles Review Committee. Now, I don't want you to discuss any response from the state in relation to the First Principles Review Committee, but are you directing the commissioners, not in the formal sense, but are you asking the commissioners to look to the principles of that review to assist in making recommendations regarding findings about a redress formula?
Yes.
Now, I just want to take you to the 4th recommended finding on that same page in relation to independent oversight of the state in relation to treaty. Clearly, this recommendation is one of great importance to the process. Has there been any discussion yet or communication to the state as to how that independent oversight might be achieved and what shape it might take?
Yeah, so there's lots of different levels around the accountability component. There's the accountability through the actual treaty making process, and we already have kind of strong measures in place for that accountability through the treaty making process with the Treaty Authority, and just really wanted to highlight the importance within that, the role of the Treaty Authority. And this was something that was a powerful part of the framework that was able to be agreed, was the capacity for the Treaty Authority to work with traditional owner groups on what their Aboriginal law was, the LORE, that they thought should apply as part of their negotiations, and to be able to have that apply, the state need to consider that and follow along with that law as part of that process. And that's a really strong part of the accountability mechanism for the treaty negotiation process. And I think we would look to kind of build on that concept as we move into the implementation of treaties, to make sure, whether it was through the role of the Treaty Authority or other mechanisms, to make sure that the state was still accountable in how it delivered on its treaty commitments. And then more broadly, looking at a role to make sure that in its commitments that it makes and how it goes about its business, that there's an ongoing process to ensure there is accountability, that First Peoples can have that capacity, like we've seen really powerfully here through Yuruk, of bringing ministers forward and the Premier forward and saying, you've made these commitments, we need to see what you're doing about it, to have that level of accountability at that level of an assembly kind of construct to the state. So there's a multitude of ways where there does need to be that level of accountability that's led and driven by First Peoples, and with the capacity to bring into that conversation our cultural authority and Aboriginal law within that framework.
Thank you. So from that answer, the commissioners can take it that you don't see it as being entirely the job of the Treaty Authority to police the performance of the government in relation to the treaty process.
No, not entirely. So there's a role for the Assembly and the future Assembly, and then there's a role for the current Treaty Authority and perhaps even an evolved Treaty Authority into the future.
Of course, you're aware of the evidence that was given here yesterday by the Minister for the Environment, Minister Dimopoulos, and indeed the question from Commissioner Walter about there being, I think, 11 frameworks, but setting out how things would be done, but very little in the way of performance itself of the commitments. Where would that type of failure be picked up? Is that something that you would see happening in the Treaty Authority, or is it something that would be picked up somewhere else?
I think that's one of those areas that's most likely through an evolved version of the Assembly, and whether that's an arm of the Assembly or a feature of the members of the Assembly, but there's definitely a need for that level of accountability, a capacity for Assembly to be able to have direct conversations with Cabinet, with ministers, with the Premier, and to be able to say, these are the commitments you've made, and to make sure there is that level of accountability to, at least if they haven't delivered on it, to understand why, and to help identify some of the barriers that might need that we can have that delivered. And I think that's really critical because, I think a lot of times when people are thinking about this treaty space, they might have concerns that there's going to be all this drastic change about a whole variety of things. But oftentimes all we're really striving for is that the level of commitment the government has already made, things they've promised to do, they've actually delivered on those. And if we're able to get that baseline, we'd all be in a substantially better place already. So a lot of times it's really just about putting in mechanisms to make sure that the government can deliver on its current promises, and then that will give us a really strong base to then progress to even greater aspirations.
Do you have any idea of the sort of mechanisms that might hold government to account? Because, we've had the Productivity Commission review, which found that there was just inertia within state and federal governments about moving from business as usual practice, which has basically meant that all the things that were promised have not been delivered. And I agree that looking at all those 10 and 11 frameworks yesterday, if they actually were delivering what they said they were promised to deliver, things would be vastly different. So what sort of mechanisms could you, to move the inertia of government to actually have structural and cultural change?
I think that's what we're seeking via the statewide treaty around that body, an elevated and permanent body, to looking at the power and functions and accountability mechanisms that we can build in. And I think we've never built this before. It's the first time, and it's got to be different. We've seen the failings, and we've seen, a lot of what has happened through ATSIC and other bodies, but this body's got to be different, and it's got to be culturally strong, and it's got to include our Aboriginal democracy, how we build that in. It's going to be quite a unique body. So that's all the discussions we're having now around the powers, the functions, the resources that we'll need, accountability mechanisms, how we can build that into, Assembly 3.0. I don't know what we're calling it, a future Assembly. That's all things that we're considering now, and the design of it.
But I'm thinking that's what First Peoples can do and will do, but I'm thinking more about what should the government do? How should they build a mechanism that holds themselves account, that gives them some sort of mechanism of actually policing their own commitments?
Yeah, so I think there's a couple of parts to that from my perspective. One is that I think some elements of those government strategies, rather than the government being solely responsible for it, there needs to be a transfer of some of those decision-making powers that sit within it to First Peoples, whether that's to an assembly statewide, whether it's to traditional owner groups, whether it's to the Aboriginal community controlled sector, that by transferring some of that responsibility, we will see better outcomes. But to my mind, it's as much about that at the moment we can try and hold the government accountable, but we're doing so from outside the room and from, a few steps below. And what I see this treaty process is about is establishing an agreement between the state and First Peoples that relationship should be more on an equal footing. So that when we are saying you need to demonstrate that level of accountability, it's not from outside the room and a few steps below, it's from within the room and at the same level having that conversation.
Is there a role for the Minister for Aboriginal Affairs in this?
If I think about my future of what the landscape looks like, that a lot of the powers of the Minister for First Peoples doesn't sit with the minister anymore. So I'm not sure what the future of it all is for a Minister for First Peoples. That's in the future. But obviously there needs to be a role for within the state to manage that relationship between First Peoples and the broader community.
Sorry, were there any other questions from the commissioners? This particular issue was one that that will vex the commissioners in preparing their report, because it appears very much to be the case that many commitments are made, many reports are done, and the delivery is often delayed or non-existent. And having some guidance from the First Peoples Assembly as to its views as to how that accountability or those accountability mechanisms can be put in place would be of great assistance. And is it possible that in advance of the treaty negotiations, the Assembly might be able to make further submissions to this Commission as to what it sees are the possible mechanisms that might be available?
It's definitely possible. Yep.
Thank you. There are mechanisms that have been mooted in the past, which I don't expect you to make any commitment to, but some of the mechanisms which have come to our attention in preparation for these hearings include a body or bodies sitting with the Parliamentary Budget Estimates Committee being able to ask questions of departmental secretaries as to performance. Are those sorts of measures the types of things that are in the broad mix of things that the Assembly is considering?
Yes.
Thank you. Now, the final recommendation is one that I've already touched on in relation to ensuring there is a sustainable and ongoing funding to support First Peoples' economic self-determination in relation to land justice, and that should be negotiated through the treaty process. I'm unsure whether you will be in a position to discuss this at the present time, but an ongoing and sustainable mechanism speaks somewhat to continuing arrangement that allows for the payment by government into an account to ensure that it happens on a regular basis. Is that what's intended by that particular recommended finding?
Yeah, that's the type of things we'll be wanting to bring to the table and have as part of the negotiations through the treaty process.
And is that the type of thing that you would see being negotiated in the statewide treaty negotiations?
I'd see it being negotiated in the local treaties, Shoshona groups. That'd be a priority for them.
Now, in the submissions, you've referred to, well, I'll just pause. Are there any other questions that the commissioners have in relation to those recommended findings? No, thank you. I now propose to move on to the part 8 of the submissions, which refers to urgent reforms. And the heading for that part is urgent reforms needed now. So the first note is consistent with something that we've just discussed, in that on page 34, the request is that the government progress and deliver on those recent reviews and matters that it has already committed to. How important is it for that to be done now, and how does that fit with the Assembly's view that things need to be done in a holistic manner? So there's a bit of tension there between the things that need to be done urgently, but ensuring that it's still done in a holistic manner. And I'd invite you to make some comment about how that can be done.
Yeah, I think it's finding the balance, because through the recent critical issues report, the government didn't move quick enough. And that's something that we heard from community around their response. But there's issues around urgent reform that can happen now. Doesn't have to wait for treaty.
And so one of those issues is the reform of the Aboriginal Heritage Act. Yes. And in terms of the urgency of it, is it a matter that it requires, from the Assembly's view, some immediate action from the government?
Yes, I think so.
Well, I mean, I think some of those recommendations are around making sure that we can move from just a system that only focuses on minimising harm, that can actually prevent harm. And so I think when we're talking about significant places that could be 60,000 years old, I think that if there's an ongoing chance that places of such great significance could just be destroyed, I think there is a need to move urgently and to raise, I think really importantly, broad awareness across the community that oftentimes when we're talking about Aboriginal cultural heritage, it's not just from a sense of, with just some desire to stop development just for the sake of it, that oftentimes these are really significant places that are being considered to be destroyed as part of these developments, and they're often just referred to in downplayed the significance of those places. So I think there's a greater need to elevate the significance of some of these places that we're talking about, because if there is a risk that by delaying some of these reforms, we are going to see some of our cultural heritage lost, you don't get that back. Once it's gone forever. And so I think in that regard, there is an importance to make sure that there's consideration of how we can get this done as soon as possible.
And it's the case that there is real hurt for the First Peoples in seeing the loss of culture and heritage.
Absolutely.
Can I just ask? This was done. The review was done in 2021. What is the state's response to date then? Those 24 recommendations.
I think that would be a question for the minister tomorrow.
So that's 3 years.
Yep.
Has there been a formal response?
Not sure, but I think that would be a question for the Minister for First Peoples and Treaty.
Again, I think I asked this about water before, but I'd just like to ask the same question about what's the importance of cultural heritage to our people? And you sort of started to touch on that, but I think it's really important that, yes, we have a lot of our mob listening in, or community listening in, but we also have a lot of non-Aboriginal people who are on their journey around understanding about our people's needs, aspirations and expectations, but also the resistance that we've shown. But, what's the importance of cultural heritage to our people?
It's so important, and I think the mainstream community don't understand the significance of our cultural heritage sites. There's sites all over this country. When I think of our traditional lands, even amongst our Assembly members, from Gunditjmara and the country that they care for is quite significant. And the Jara, there's many sites within the Jara. I know myself as young Balug, the sites that we have bought around 400 plus scar trees, and all the time we're seeing our scar trees desecrated because they get chopped up for firewood. There's country in Gunditjmara country that's World Heritage listed. There's sites all over this place that mean so much to us. It's where we come from, and we've got burial grounds too. When you look at Cow Swamp and the ancient burial ground there, and the significance of these sites, and we've had to watch them be desecrated. We've had to see over the years our ancestral remains be dug up and desecrated. There's a lot of examples that we have, and where we're still repatriating our ancestors to this day. So the cultural heritage significance of this country is something so sacred and special that, the wider community need to understand the significance of it and the thousands of years that come with it, and our custodianship and our care for those sites. As Ruben said, with the Victorian Heritage Register, like the Carlton United Brewery facade and the bridge at Hawthorn has more respect and recognition than our ancient burial grounds on our country, or Budgebing with the aquacultural systems that they have that are so ancient and older than the pyramids. And that's something that you would have talked to the Gunditjmara about. So I think that, there's got to be more awareness around that, and it's something that we share, in our country, and that's something that we bring. And I think even in our recent statewide gathering, Justice Joe Williams, he came over to speak with us, but talked about the gift of legitimacy and what we bring to this state. And I don't think that's recognised or respected, and something through treaty, through our dialogue, I think that's, important for us to highlight around the care that we have for this country, our sacred sites, and that we've had to sit back and watch them be desecrated and, have minimum harm through the different acts, but it's not good enough. And I think that there's something that we can all share around our history and learnings of our sites, and, some things are our business, but there's ways that we can bring in, non-Aboriginal community to share in these significant parts of our country. So I think there's a lot of good examples that we can share, and of our sites. Everywhere you walk is Aboriginal land, and we've got blood in the ground. That's our connection. That's what makes us so strong, because we have our ancestors and that connection to country. And I think it should be shared more broadly and right across this country. It's, one of the most diverse and beautiful countries that we have. Our land, and something that we offer is our, 60,000 plus years and the oldest continuous living culture in the world. So I think that's something that we can all share and celebrate, our culture and our languages, and
So outside in the foyer here are the photographs by my dad, Jim Berg, of the scarred trees that he's taken. And the scarred tree to me is always such a powerful element of our cultural heritage. And it's not just about the scar itself, it's the tree itself, where there's been bark removed to make a canoe, for example. It's what that represents in the broader sense. And to me, it's that those scarred trees represent that deep connection we have to the environment and to the land. Because if you think about it, if you wanted a canoe, one choice is you could just go and chop down a tree and you could make a canoe. But then there's no more tree left. And our ancestors worked out that you don't need the whole tree. You can just take off this single sheet of bark, make a canoe, and the tree will still get to live. And so those scarred trees are a powerful reminder of that connection we have to the land. And that's why they're such a critical element of our heritage to be protecting.
And we've heard evidence in our travels around the state, particularly about Nagara mentioned about repatriation, but we got our ancestors and secret sacred objects spread throughout the world. Do you want to make any comments about that?
I think it needs to all be repatriated. It's hard because we've got provenanced and unprovenanced cultural items, ancestors. There's the stories of the bone collector on the Murray River that, dug up our ancestors for a sixpence or a shilling back in those days, and we're still returning those ancestors. There's a story of the Jara baby that we repatriated back to the tree that was in a museum for 100 years and was researched over, a century. And we had to fight to return that Jara baby back to country and back to the sacred burial ground. And every one of us across our assembly would have stories of our ancestors and, in museums right across the globe and in our own museum. So there's a lot of work we need to do to repatriate our ancestors back to country and to have those burials that we need to do to put them back in the rightful place.
You raise the issue of provenance. In some cases, there's not enough information to know where people have come from, and you would know that in many cases very sacred cultural items were taken, and the provenance of those items is not known as well. And so does that cause an issue with people not wanting to take things that are not necessarily from their own country or their own people?
Yeah, I think that's definitely, it is a complicated space, and those are some of the considerations. And there's also the consideration of the capacity for groups to actually look after and protect things that might be repatriated. So, but the overall principle should be that where we know where something comes from and a group wants it returned, it should be returned.
Just going back to the review of the Aboriginal Heritage Act, the recommendations, it's noted in on page 35 of your submissions, the recommendations made by the Aboriginal Heritage Council sought to align the Aboriginal Heritage Act with the United Nations Declaration on the Rights of Indigenous Peoples and embed principles of free, prior and informed consent. If those principles were embedded, how far would that go to the sort of protection that is needed to ensure that these items are properly protected, or places?
Yeah, I think absolutely would be a powerful step forward. And a key part of that is the self-determination aspect of it. It's the independence of that Heritage Council to be able to be not necessarily under the banner of government, but to be able to be an authority that can exercise the rights of First Peoples through that lens.
You've also mentioned in the submission the first principles review of the Traditional Owner Settlement Act. That's a matter about which some questions will be asked of the Minister when she gives evidence tomorrow. But it was initiated in 2020, and that's a matter about which, from the submission, it appears that the Assembly says there should be urgent reform flowing from that review. Is that correct?
That's correct. And with all of these, though, as Nagara said, there is that important balance to be met. But I'm always mindful that the government is a significant beast of an entity. And I fully expect that some parts of government can do one thing while another part of government is doing another. And whilst we are mindful that from a treaty perspective, we are looking at ways that we can have systemic reform to address some of these things. And so some elements of those reviews are rightly set aside for treaty. There are some aspects that don't need to have that delay. And likewise for the Heritage Act and for the First Principles Review, that there should be the capacity for the government to chew gum and walk at the same time.
Mm. Similarly, the Public Land Act review process has been underway since 2021. You referred to that in the submission as well at page 35. And that hasn't come to a conclusion yet either. That's correct?
That's correct. And the current status is unknown.
Current status is unknown. Mm. And then at page 36, at chapter 8.2 of the submission, there's a reference to implementing existing policies and strategies, and some of the policies and strategies are set out in that in those paragraphs. Is there anything you can say about the government's performance in that regard?
I'd say that broadly, as I mentioned before, oftentimes Victoria is on the forefront of some of these things. And so there are some really powerful aspects of those existing policies and strategies. And it's about making sure that that's not seen as the benchmark of that's acceptable enough approach, that we want to make sure that we can build and strengthen on those things. And that's possible through the treaty approach. But that doesn't, again, as I say, prohibit the government in its breadth of being able to address some aspects of that immediately, bearing in mind that some aspects of that systemic change do need to fall under the treaty landscape.
So, so in particular, you've referred to the Department of Environment, Land, Water and Planning document, Water is Life, Traditional Owner Access to Water Roadmap 2022, the Victorian Aboriginal and Local Government Strategy, and the Papungali Manmanapu Owning Our Future Aboriginal Self-Determination Reform Strategy 2020 to 2025. They are some particular strategies that you've identified. And do I take it from your answer to the previous question that there are elements of those that you see as necessary for urgent implementation, but some parts that can be or should be dealt with under the treaty processes?
I guess from my perspective, personally, it's more the case that oftentimes these strategies go as far as they can within the current systems. And so within those systems, they are pushing the boundaries, but they come up against, at a certain level, a barrier. And so whilst those barriers are there, the government should be implementing those in full, but we can use the treaty negotiations to try and remove some of those barriers that might be prohibiting some of those initiatives achieving the stronger outcomes they could be achieving.
Now, at 8.3 of the urgent reforms section, you refer to ensuring that the current laws, policies, regulations and agreements meet the minimum standards of the United Nations Declaration of the Rights of Indigenous Peoples. So the Assembly's position is that, as we understand from this submission, that those minimum standards are not met in all cases by the laws and policies, regulations and agreements in place. Is that correct? How close do you think that or do you think that there is any consistency with the articles of the United Nations Declaration on the Rights of Indigenous Peoples?
I'd say to a degree there is, but I think as we mentioned there, it could be definitely strengthened. And I think this is another one of those examples where there should be comfort for the broader community to recognise that we're looking at these international standards about how we go about doing things, that this is not Victoria going out on a limb and doing something quite radical. It's Victoria trying to line up with internationally recognised standards about the rights of Indigenous peoples.
Is there a position that the Assembly takes as to whether that should be a legislative requirement in Victoria? That there is legislation embedding the United Nations Declaration of the Rights of Indigenous People into state law or adopting it?
I think that's still something that's part of our considerations. And to my mind, it's less about the broader philosophies, it's putting it into practice through what treaty can achieve. So I think at times there can be a tendency to just fall back onto the principles under UN Declaration of the Rights of Indigenous Peoples, but there's a capacity to actually activate it rather than just defer to the principles. And that's what I'd personally much more interested in seeing activated through treaty.
Do you wish to add anything, Nagara?
Yeah, I think it should be applied in all aspects of their approaches, and that's something that we talked about in the framework and embedding UNDRIP in the framework. And the state will also have requirements to apply to the treaty authority around minimum standards. So you would think that that would be considered from a treaty authority perspective. But yeah, absolutely think that it should be applied to their approaches.
Thank you. The fourth matter, paragraph 8.4.
Mr. McAvoy, can I just ask a question before we move on to that?
Certainly.
Going back to 8.2, the existing policies and strategies, this is an issue, I think, both for URUK and ultimately for treaty. The government has expressed very supportive strategies, principles, frameworks, guidelines, but the history of implementation is is very sadly lacking or extremely slow. And I mean, there are some examples there, but we know of others like principles review. And one of the things that we and you will need to grapple with is why that is the case. Why in a well-intentioned government who's expressed supportive principles and frameworks, etc., has there not been the delivery? I'd be really assisted if you were able to inject some ideas as to why that is. I mean, obviously, we'll investigate this with government itself, but you've obviously had wide experience in dealing with government and maybe have some light to shine on it, because it's from a knowledge basis that you would move ahead in negotiations. And from our point of view, from evidence that we hear, we'd move ahead to make recommendations to overcome those barriers.
Yeah, I'm happy to chime in with some initial thoughts on it. One is that I think oftentimes there's this kind of inertia that can set in within government, that things are moving and done a certain way and business is undertaken in a certain way, and it can be challenging with such a beast of government to kind of shift that mindset, that approach. And so often we'll see that at the minister level, the secretary level, there's a strong willingness and a commitment. When it gets down to the actual public servants on the day-to-day, that's where you can come up with some of the difficulties in changing that mindset and breaking away from this is how we always do stuff, so sure that we keep doing it the way we've always done it. I think another aspect of it, and there are lots, but two that come to mind now, is that a lot of times these initiatives are putting huge burdens on traditional owner groups to engage with it to actually see results. And these traditional owner groups aren't actually resourced to be able to provide the requirements of that. So if we can move to a place where traditional owner groups through treaty are much better resourced and have the capacity to engage with the state on these sorts of things, then we can see some great progress as well, because oftentimes, as I said, there is a huge impost put on traditional owner groups around what their obligations are, but with not the resources to back that up.
Have you got an example of that springs to mind? I've got plenty of examples for your point number one, but at this impost on TOs, is that something where you can give us an illustration?
Yeah, off the top of my head, just one example from the kind of water space is there was a keenness through Water is Life to obviously engage traditional owners more strongly in planning for environmental water activities. And so that's part of the policy, but you actually need to have dedicated staff and resources within a traditional owner group to be able to actually come to the table. And there was often a keenness for groups to want to be involved in planning for the delivery of environmental water, but they just didn't have the capacity to be part of those conversations, as an example.
I seem to recall that the strategy included resourcing TOs. That didn't happen.
Oftentimes it's not sufficient for the needs, and there's a sense of, I think part of it is there's often this idea that one person can represent the view of a traditional owner group. And that's often the failing, is that if we as a community want to actually make a decision about environmental watering, it's not going to be one person's job to decide how that happens. It takes bringing the community together. It takes a common understanding. It takes a lot of work. It's not just you've got one resource and they should be able to decide. I think that's some of the limitations of it from my perspective.
Going back to point number one, the inertia point, we can make a recommendation that there be no inertia, and you can have a treated discussion that abolish inertia, but how do you do that? I mean, this is a sort of an internal public service malaise, if you like, and it probably doesn't only affect these types of Indigenous issues. How do we do something that is meaningful about overcoming that one?
That's a far tougher question, but I can give you some of my insights for what it's worth in that space. I think it takes the leadership to be really strong about this within government, to not just give it a cursory idea that, yeah, this is a good idea, but we're not really going to talk about it much. It takes actually that commitment to reiterate and express why this is important. And it takes the public servants to actually not just do it because they're told to do it, but to really understand why this is happening. and that broader awareness, which I think can stem from the work UWOOC's doing about why it's important to do this, so that that can help overcome some of that inertia. But there's not a secret weapon that's going to unleash all of that. That's a much broader problem. But some of those things I think could assist in that.
And I think we're unravelling all those existing policies, and there's so many arms of government when you power map it. So I think there's some consolidation that needs to happen, and that as well. And that's something that we're considering, through our work with treaty.
I think that one of the challenges that we're also facing is that in the criminal justice and child protection system, we asked every minister and bureaucrat beforehand about how much power and resource they transferred over, and none was identified. But where one minister came forward and tried to articulate where it happened, it was really transferring a broken colonial system to our people to implement.
And that's what we don't want to inherit when we talk about a future assembly or mirror a white collar system or parliament either. So that's things that we're considering as well.
Yeah, I mean, because I think, and we had the Minister for Environment yesterday who was articulating where the department felt that self-determination was enacted was really about collective inclusion rather than adhering to or empowering collective rights. Yeah, a lot of joint management and so forth, but not so much in the context to implementing and recognising and upholding collective rights that our people hold. It's very much, we'll include yous and we'll fund yous to do some cultural firework, but it's not actually about transferring power and resources in I guess, the effect as to what yous are actually talking about.
I think something else that came out of and it's with all the ministers that we've talked to, with all of these, I mean, there's hundreds of these strategies and frameworks, is that there is no line of sight of responsibility. The minister here yesterday said that he didn't, and he was going to look to do that, but he isn't alone, that there is no line of sight, and these just proliferate. And because there's no heads roll. When this fails, like you've got here the 20 to 25, owning our future. What's going to happen in 2025 when that isn't delivered? Will there be any consequences? It seems not. So,
yes, that inertia concept is we've done the strategy framework principles, and that's the job.
I think, Commissioner Hunter? I just wish to explore that a little bit further with you, that issue of inertia, and by inertia, in the sense that the commissioners have used it, I understand them to be saying that government likes to do things in the way that it's always done them. And the ways in which government has always done business as far as it affects First Peoples is that they have done it to First Peoples or on behalf of First Peoples, and not as partners or at the direction of First Peoples. That's your understanding of the discussion around inertia?
Yes, that's correct.
But I suggest to you that whilst there is, I think that the evidence discloses that there is a degree of inertia, that it's not entirely benign in the sense that it's just government being itself, but that the evidence that we heard yesterday, for instance, about government actively arranging its business so as to avoid paying money to First Peoples, indicates that there are other forces at work. Would you accept that that was the case in the evidence yesterday? Is it your view that may still be the case today in 2024, that there are agents within government who see it as their role to deny First Peoples the access to the levers of power?
It may well be, yep.
And how do you deal with that? How does government deal with that? How do you have any suggestions for the commissioners as to what the Minister for Treaty might do about that, or the Premier might do about that?
They are some important questions for the Minister tomorrow, and we understand the power imbalance And I think yesterday the minister spoke to that example of where the system's designed against us and stacked up against us. And that's all part of the conversation that we're having now around the power imbalance and how we shift that and the dynamic and behaviours. So that will all be part of our, negotiations when we get there. And I think the beauty is that we have a treaty authority and we have 32 members in the Assembly that are going to take up that fight and make him accountable. And we'll get to that when we get to negotiations.
Is there anything you would wish to add on that point? Thank you, Ruben. They're the questions I proposed to ask today, Commissioners. I had indicated to Ruben Berg that he would have an opportunity just to make some closing remarks, and unless there are other questions from the Commissioners, I would invite him to do that now.
We're talking about land injustice here, but there was a really good point made yesterday to do with when the Yorta Yorta case happened and not taking into account the bringing them home report and that the removal of people from country. And so when we talk about that and then we talk about frameworks and policies and then you talk about what needs to happen now, can I just ask, and you can answer it or not, your response to the child protection and criminal justice recommendations of the harms happening to people today, what would you say to the government in response to those harms, children being removed, people dying in custody? What would you say to them in the balance of that, not with our current recommendations? Would you say there's things they can do now?
Absolutely. And I think it's incumbent upon the government to have heard that so many of our people came forward to be part of that process and shared their stories, which are often quite traumatic stories as a part of that. And it's really critical to make sure that the recommendations that came out of that are not just seen as support in principle, but that they are seen as actually to be enacted. And that's something, just like Nagara's been talking about, that we intend to hold the government accountable for making sure that they do that. And as I said before, it's being able to do so not from outside of the room and from a few rungs lower, but from inside the room and on equal footing to have that accountability.
At the statewide treaty gathering a couple of weeks ago, there's some strong questions and aspirations from community about ongoing truth-telling. So you are well aware of our mandate and our terms of reference and our timeframes that we're working with to deliver a report by June next year. Do you have any thoughts and suggestions in relation to what does ongoing truth-telling look like beyond the mandate of ULUC?
Yeah, I definitely think there's a legacy piece, and we hear that from community around what is it going to look like after the report is finalised. And we get a lot of suggestions and ideas around a Truth Institute, a museum that holds our truth-telling and our stories, archives. We get a lot of ideas from the mob around what it will look like. So I definitely think there's a legacy piece there that will carry over because people are going to keep coming forward to tell their truths, and it's got to be ongoing. So yeah, I think we'll consider all of that and wait for the report as well around that.
Ruben, are you able to make some closing remarks on your and Nagara's behalf?
Yeah, absolutely. I think on behalf of myself and Nagara and the other Assembly members who are here and those who are not here as well, and on behalf of the Assembly team, it's been a really powerful process to be able to be involved in. And I know for myself personally, it's been overwhelming to be able to be part of such a process and to be able to sit in this space with majority of First Peoples around this table, knowing that this is a process that we initiated as First Peoples, that's being led by First Peoples. It's a really powerful testament to the work that we all are doing. And I think it's really want to reach out to all members of our community who have participated in this process and will hopefully continue to participate in this process, and to know that there is these systems in place to make sure that the stories that people are coming and sharing are being heard, and that there's systems in place to make sure that we will see systemic reform to address these issues that have been raised. and that the Assembly is here as the representative of First Peoples to hold government to account on those things. But just really wanted to reiterate the amazing work of Yuruk has been doing to get us to be able to tell these stories and to really open up an invitation to the broader Victorian community to really have the courage and the strength to really embrace what Yuruk is doing and to delve into and unpack the stories that are being told, because it's really important that the broader Victorian community understand the truths of what has happened to First Peoples across decades and centuries, and to recognise that these things are still having a lasting impact on First Peoples, but to recognise that there is a path forward, through treaty, and that will lead us to that treaty future that I aspire to, which is where our communities are thriving and our cultures are at the heart of our daily lives. Thank you.
Commissioners. We might adjourn at this point and the witnesses be excused, and we will return at 2 p.m.
5, 2 minutes. Yep.
Sorry?
Yep. 2 p.m. Yep.
Thank you.
Thanks very much for coming in today. Thank you very much. Thank you. Okay, the sitting of your Justice Commission is now resumed. Thank you, Council.
Thank you, Commissioners. We now have Paul Patton, the CEO of the Federation of Victorian Traditional Owner Corporations, here to give evidence. Paul, could you please introduce yourself in whatever way you would like to culturally to the Commissioners?
Umaninji, Nurange, Neto Makta, Paul Payton, Naju Bajri il Wokwok Murach, Naju Lung Gunai, Naju Lung Manero, Naju Lung Gunditjmara. Naju Tanganai Warandru Woirang Wokwok, Ba Wulu Wulu Gani, Naju Tanganai Neto Wulu Wulu Gani. Naju Tanganai Wada Wokwok il Gani Lung Wokwok. Anikba Bunyabuk Tinkara Wuran. My language, Gunai language, I said, how are you? It's nice to see you today. My name is Paul Payton. I am well, the country is sick. I belong to the Gunai, I belong to the Monero, I belong to the Gunditjmara. I respect Wurundjeri Woiwurrung country and also their elders. I respect my old people, my elders. I respect all country and people belonging to country. I want to thank you for the opportunity to be here today. As a Gunai man, I want to pay respects, particularly to my elders, and particularly my grandparents, both Albert Mullet and Rachel Mullet, Monta, who have provided me with significant guidance in my life journey to be able to advocate for our rights and to be able to maintain a connection to my family, to my country, to my people, and also want to acknowledge my mother, Doris Payton, who, despite significant adversity, has enabled me to maintain that connection and continues to influence me every day. Thank you.
Right, yeah, welcome. Yeah.
Thank you for sharing your language. Thank you. That's really important in this space. Sorry, I know it's not on.
No, Commissioner, you're the boss. Paul, do you undertake to tell the truth to this Commission today?
Yes, I do.
I understand you would like to read a short opening statement, and I invite you to do so now.
Thank you. Land is life, land gives life, and land sustains life. Land is us, and we are land. Land is central to what we call country. Well, country is the land and the waters and the skies and their many resources. Country is part of us, and we are part of it. Country is our family. Country is our culture, our language, our customs and spiritual beliefs, our traditional knowledge and teachings. Country is the plants and the animals, the birds and the fish and everything that makes up the intricate ecosystems that connect and sustain us every day. Country is a living entity with memory and consciousness. Our connection to country flows from the past and influences the future. Our connection to country gives us our identity. The country is us and we are country. Stealing our land was at the very heart of colonisation, resulting in the violent separation of our people from the country, the very land that gave us and sustained us for millennia. Perpetuated through the falsehood of terra nullius, since this has had devastating consequences that are still experienced today. Our people were massacred, removed from country, forbidden to practice culture, and every attempt to was made to destroy families and our identity. This is all well documented in the historical records. It was an attempt to destroy our oldest living culture in the world and replace it with systems and institutions that have inflicted ongoing damage to country that in turn has damaged our people, our culture and our spirit. Colonisation and the theft of land also deprived our people of their material livelihood, setting the stage for economic deprivation and continuing poverty in a community where many of our values were rejected and our skills in limited demand. Colonisation and the dispossession of land and natural resources is not only in the past. This is not purely a historic legacy underpinning dispossession and socio-economic disadvantage. There are active forms of dispossession that are continuing to be systematically applied by the State of Victoria through public land management and administration. Contemporary acts of colonisation continue to entrench dispossession and reinforce the advantage and privileges of the dominant settler culture. Any recommendations to address land justice in Victoria need to be underpinned by and consistent with the obligations under the United Nations Declarations on the Rights of Indigenous People. This is grounded in the core principle of self-determination and requires access to and partnership in decision-making processes around land and resource management. Aboriginal self-determination cannot be achieved without economic development and a level of economic independence supported by a strong Aboriginal economy. Traditional owner access to and authority over caring for and healing country and its resources is considered central to maintaining connection to country and the maintenance and practice of culture, including the management and protection of our cultural heritage. The Cultural Landscape Strategy, which we'll discuss today, the first of its kind in Australia, sets out a framework to systematically enable Victorian traditional owners to lead, planning and activate cultural knowledge and practices to manage country. The framework enables traditional owners to use Indigenous knowledge to protect, manage and heal cultural landscapes in partnership with government and private landholders. The framework includes bridging tools that bridge the two knowledge systems, Indigenous and Western scientific, to lead to changes required for traditional owner-led planning, management and governance of cultural landscapes. Land justice is not merely a mechanism by which to acknowledge historical injustice, but also a contemporary issue critical to the journey of self-determination. Land justice can only be built by agreement. The state must work proactively with traditional owners to achieve a just, fair and durable agreement to ensure the long-term existence of traditional owner groups as a distinct cultural, social, economic and political entity within the broader Australian community. Thank you.
Thank you, Paul. I understand you're the CEO of the Federation of Victorian Traditional Owners Corporations.
That is correct.
And how long have you been in that role?
I've been in the role since April 2020.
And what's been your professional career prior to that role?
Of that role, I spent 2.5 years at DELP, the Department of Environment, Land, Water and Planning, as Manager of Partnerships and Engagement. Prior to that, I spent 14 years as Executive Officer at the Victorian Aboriginal Corporation for Languages, supporting communities in the revival of their languages across Victoria.
Can you briefly explain to the commissioners what the role and work of the Federation is?
The role of the Federation is an advocacy body and a convener and facilitator for traditional owners to advocate for their rights and interest, to reform legislation and policy, to enable self-determination, to embed recognition in government policy, and to build capacity for traditional owners to be towards economic independence and strong nation identities as a collective group.
And a number of your members, if I can put it this way, the number of the traditional owner corporations would be registered Aboriginal parties under the Aboriginal Heritage Act. Is that right?
That's correct. All of our members, all 6 of our members, are registered Aboriginal parties.
And would some of those also be traditional owner entities under the Traditional Owner Settlement Act?
Yes, several of those are such as Jara, Glowak, Tunarong, and soon to be Eastern Mar. So a few of our members are traditional owner group entities.
And Glowak, you mentioned Glowak. Glowak would also be a prescribed body corporate under the Native Title Act as well.
That's correct.
So the Federation has prepared a submission regarding the Commission's Land Injustice Inquiry that suggests a number of recommendations that should be implemented by the state. If I can just go to page 13 of that submission, and in particular, if we can highlight the 3rd to 5th paragraphs. Um, uh, the submission states that in achieving land justice for First Peoples, this deep connection, being the connection between First Peoples and country, must be genuinely recognised and firmly understood as underpinning all aspects of First Peoples' existence. Do you think that that deep connection is widely understood in Victoria?
I think that widely understood through the broader community is probably not understood to the level that is required for us to come together as a country, as a community, and to be able to build a future together requires a deep level of understanding about our true history and referring back to my statement around the false pretense of terra nullius, which is being passed on through generations throughout this country, has become the status quo, or the kind of the understanding of this country about our history, and therefore we have a huge role through the Truth and Justice Commission, through treaty, through our education systems, to be able to ensure that our true history is told, so that we can walk together for a shared positive future.
And the submission goes on to state that the importance of land to Aboriginal Victorians is rooted in the core principle of self-determination, and that the deep connection between First Peoples and country must be genuinely recognised and firmly understood, and that self-determination requires access to and partnership in decision-making processes around land use and resource management. Why is that important to self-determination for traditional owners?
I think having rights over country provides us the ability to exercise our obligations as Aboriginal people, as traditional owners, to manage country, and that is something that needs to be enabled through the activation of proprietary rights to be able to manage country, and current systems and land tenures don't enable us to fully apply our obligations to care for country. So we need to move to a new land tenure position to be able to enable that practice of rights and the obligations, because it connects us to our culture, our story, and to be able to not to be able to practice those obligations on country causes us trauma, because of that inability to access country to fulfill our obligations, and we need to be able to self-determine what that looks like, and we need to remove the barriers to allow us to practice our culture on country, and for that to be designed in a self-determining way.
What are some of those major barriers, in your view, to access to land and resources?
I think probably as most significant barrier to access to land is a lot of, I get a significant proportion of the state native title has been extinguished. Therefore, there are no native title rights to be able to access land that's freehold title, and public land that still exists is only in small patches, if I could describe it that way. There are some parts of the state that there are large patches of public land or areas of public land. However, those areas of land still are sort of those areas of land are still under Western management regimes. Therefore, those opportunities are very limited to be able to fully exercise self-determination and cultural practices on country. So that's where I come back to my previous point, which is around options for future land tenure that allows traditional owners to actively manage country. So the significant barrier there is the Western land management regimes that don't fully align with traditional owner cultural practices and needs as far as our spiritual, our obligations to manage country. Those regimes don't facilitate that, and you see, and I don't want to diminish the hard-fought gains by traditional owners when they achieve Traditional Owner Settlement Act outcomes and native title, because they are significant outcomes. But when it comes to the implementation of those agreements and those rights, they are still held within sort of guardrails, let's say, to be able to only undertake certain activities. So that's where new forms of land tenure can open up those opportunities to allow those cultural practices to occur.
And I'll ask some questions about those issues soon, particularly in terms of new forms of land tenure and some of the constraints on traditional owner capacity through the lens of the first principles review. But going back to that notion of the hard-fought gains, and particularly from the perspective of your members, there have been 5 native title determinations, positive determinations under the Native Title Act in Victoria since the passage of the Act in 1993, and 4 recognition and settlement agreements under the Traditional Owner Settlement Act since 2010, and that's directly relevant to your members. Would you have hoped there would have been more determinations and agreements made in that time?
I think first we need to recognise that the time that needs to occur for those processes to reach an outcome. Often, and it's been mentioned in previous hearings around the trauma that's occurred to our people on country, to our communities, to our histories, our connections, and those processes to address, to bring people together, and move forward together, do take time. There is a recognition of that. There is certainly what support mechanisms to be able to bolster up those activities that work towards those outcomes have, in my view, haven't had enough sufficient resources. And whilst you don't want to speed up the process, there are certain, I guess, outcomes that you can expect by having more resources available to the groups to be able to proceed through those particular processes. So I would say that it would be possible, but it needs to be a respectful process. And I would suggest that processes for of this nature need to be culturally safe, culturally informed, and follow cultural protocols to ensure that things are properly considered, and that that the future of the group is at the centre, and for country is at the centre of all processes.
And you've mentioned there that you've drawn a distinction between taking the time to do something right, but making sure that traditional owners are properly resourced to participate in those processes. Do you consider, from the perspective of the state, that it puts enough resources into its own capacity to participate in those processes and attempt to deliver negotiated outcomes under those land justice legal frameworks?
I think the state is well resourced to be able to service whatever its need may be. The resources, there needs to be an increase in resources from the state to support that foundational work. If that's the objective of the group, is to pursue formal recognition, then the requirement on the state to acknowledge and address our history and what has contributed significantly to where communities are in a contemporary context, then all resources should be, to the fullest of its ability, should be provided to those groups to participate fully in that process. So if you were to analyse that, you would say that the state provides its access to its own resources, and I can't back it up with any numbers, but my observation and experience throughout the years has observed that the state has limitless resources available to it, and it only provides minimal resources to traditional owners to participate in that process.
And the commissioners have heard extensive evidence about the impact of colonisation on Victorian traditional owners, and you've already discussed it as well in your opening statement and throughout your answers to questions. I'm interested in your observations as CEO of the Federation and the member corporations. We've talked a lot about the continuing impacts on community and individuals. I'm interested in whether you see any impact of colonisation on the capacity of traditional owner corporations to function and do their best for their own community.
Certainly, it's a common conversation and observation around the capacity for traditional owners to, I guess, pursue their own nation interests, to be able to engage and partner with local communities, local businesses and organisations, and a significant ask from state departments and agencies who wish to partner with traditional owners. However, the resourcing of that partnership to be able to activate the outcomes, to achieve the outcomes that are sought through government-driven policies, as something that we've advocated for many years over, to establish centralised foundational funding for traditional owners to be able to set up the the systems, the processes have the capacity to respond, and there is an unequal an unequal kind of resourcing that occurs when you compare like for like with traditional owners and the work that they do across a range of portfolio areas, and then agencies such as catchment management authorities and the like that are significantly resourced over and above traditional owners. So there's an inequity there, and it doesn't recognise the breadth of work that traditional owners are faced on a day-to-day basis.
If we can bring up page 21 of the submission, and I just want to go to the final paragraph. So, and this goes to your issue around proprietary rights and new systems of tenure. So in the submission, it says the Federation further submits that real land justice is not merely a function of land handbacks, buybacks and compensation. Real land justice is achieved through the recognition and creation of proprietary rights, specifically applicable to the Victorian economic context, that ensure First Nation groups in Victoria are supported in their economic development goals. Has the Federation given any thought to what type of proprietary rights you would like to see recognised and created, or put in another way in terms of your language today, changes to the system of land tenure that need to occur to better align with Aboriginal worldviews of country?
I think that different forms of proprietary rights extend beyond property, in land. Property rights that that are existing and continue to be granted now and into the future, that are resources from country that traditional owners may have a right to and an interest to be able to benefit from those rights, as has the state. And I think to fisheries rights that have been granted that have not delivered any commercial outcomes, any rights for traditional owners. I think of renewable energy and the rights that are being afforded there, flora rights in regards to native foods and botanicals. I know we'll come back to that. And even looking forward into biodiversity and carbon credits and rights that are on the horizon, and that are going to probably dwarf the numbers that we heard from Minister Dimopoulos yesterday around income from forestry and from grazing licenses and so forth, and where traditional owners are on the cusp of missing out on those rights yet again. And also water rights that have, through the commodification of water and the entitlements that were afforded to farmers that traditional owners saw nothing of. The industry, I think we've submitted, as part of our submission, some research around the value of the water industry, estimated to be valued at around $11 billion at 2023. So, and that continues to grow and increase. So, I think rights, the proprietary rights across a range of areas is something that needs to be better understood and addressed, and how we address those historical granting of rights, and how do we ensure that traditional owners don't miss out again in any future rights that are being granted. So, there needs to be real consideration by the Commission about what recommendations it makes in regards to the future granting of rights, and which could potentially prejudice treaty negotiations. So whether there needs to be some kind of moratorium or something of the like that looks at, or some commitment to partner with traditional owners to ensure that there are rights afforded traditional owners in the future granting of rights, then that is critical in the next immediate future.
Can I just ask to clarify? So yesterday we heard that the rights for traditional owners to get monies were put there, but it was carefully calculated to make sure that those rights could never be exercised. So I'm just wondering from your answer, are there current rights which are proving to be shallow, or where right exists on paper, but in actual fact the right doesn't amount to much? Or is it complete absence of First Peoples in these granting of rights, or is it a combination of both? And if it's a combination of both, you could give us an example of where there's supposed rights that aren't actually resulting in outcomes, or in other places where traditional owners' rights have not even been considered.
Thanks for that question. I'm trying to think of an example to provide to you, Commissioner. I think the one, not a combination, but water rights comes to mind as far as the limitations, and there was a process of the development of Water is Life undertaken, and still contained within that. Traditional owners had to fight very hard to even for government to keep the door open for access to water rights. So it's only partly open, let's say. However, those real rights haven't been realised. I can't think of another example for you at this point in time, but happy to come back to you.
Can I just add to that? I'm pretty sure the government are quite proud of Water is Life, yet it's limited and there's not very much wiggle room, is really, so to put it, for rights or there aren't rights in that for water rights for traditional owners.
Right. Water is Life is a significant and somewhat commendable strategy, but there are limitations contained within it around those entitlements and those rights that government was not willing to kind of entertain.
But they consulted, right?
Yep. And traditional owners advocated for an increase in those entitlements and those rights, and they were rejected.
Thank you. Sorry, just processing.
We might then turn to some of the strategies developed by the Federation to attempt to deal with some of the issues that we're discussing. And the first strategy I want to discuss is the cultural landscape strategy. And just I might in the background bring up the poster that summarises the strategy. And there's a graphic at page 2 just in the background. So just before we turn to that graphic, when was the cultural landscape strategy released?
Released in August 2021.
So to the extent that it had either commenced or before or after your commencement as CEO, do you know what the background to the development of the cultural landscape strategy was?
I think it was a culmination of what traditional owners have been saying for some time around the need to be able to incorporate traditional owner governance, traditional owner knowledge and practice into bring together with Western management systems to ensure that they are appropriately brought together to be able to apply and manage country. So it was an initiative of traditional owners through the advocacy of traditional owners to the department, and to be able to go on this journey of a cultural landscapes strategy, and what are the objectives of such a strategy, what are the requirements, the components as it's described in the strategy that would need to be played out, but what are the outcomes that were being sought, and how do traditional owners and government work together, and this provides a framework to enable that.
And I'll take you and the commissioners to an example soon. But in your opening statement, you mentioned the concept of bridging tools, and it's a unique feature, at least to me, of the strategy appears to be that it takes as a given the existence of various government strategies on various issues that might have an Indigenous component to it, or be wholly in relation to Aboriginal Victorians, but it overlays traditional owner priorities in their own words and according to their own aspirations over the top of or in conjunction with those strategies. And so am I right in saying that the cultural landscape strategies and other strategies developed by the Federation are that attempt to put in Aboriginal language and Aboriginal concepts, the government strategies that exist to create an overlay of an Indigenous worldview onto those strategies?
I would agree. I mean, it's the first of its kind in Australia, and it's different to other strategies that Federation has developed and with traditional owners, in that it's a framework for how traditional owners and government work together. Traditionally, other strategies have identified what are the barriers and opportunities, and it does address that to some extent, but this focuses on how to bring knowledge and practice together and work in partnership with government to achieve those shared objectives.
So just on the cultural landscape strategy, in your own words, what is a cultural landscape?
In simple terms, it's a conceptual unit, and that's conceptualized by traditional owners, and that would look different to each group of traditional owners. But a conceptual unit, if you can imagine, it could be an area of country that is significant for its resources, and that's just, and it has a cultural component, a cultural kind of lens that's applied to it to be able to understand and access that country, or it could be an entire traditional owner country as a entire cultural landscape. So, and anywhere in between, it could be, and these are just sort of suggestions, that it could be described as a traditional songline that moves through country as a cultural landscape. So it's the concept. Like I said, it's a conceptual unit that's ultimately described by and identified by that traditional owner group or individual potentially.
And at the core of the strategy, it appears to be a desire to heal and restore country as part of the cultural landscapes strategy. I mean, it might be obvious, but why is that important to the Federation?
It's important that traditional owners are able to identify and where their rights and interests are not being met. It's important for the Federation to be able to understand that from a traditional owner view and aggregate that across multiple traditional owner groups to be able to form an understanding from a statewide perspective around what needs to occur to address those issues. So it's important that for Federation to have a deep understanding of those groups' priorities, their country plans, their challenges, their relationships, and that's including our relationship with them, to be able to provide that support when requested, to be able to advocate more broadly around it, so that there's an awareness of these issues and an expected response from government to address these issues. And it's critical that those issues that impact traditional owners across the state are excuse me, addressed at a statewide level, because often those types of matters are addressed in a legislative context, and the legislation probably yet to be tested usually applies at a state level. I'm starting to think about other ways to be able to apply legislation that operates at a statewide and a traditional owner level. This is in my thinking at this stage, but yeah, it's important that those conversations occur and those relationships are maintained to be able to address the years of mismanagement, the years of on country, and the years of dispossession and the barriers that have been placed, and we're continuing to unwind those through these processes.
And so you mentioned there are a number of program components in the language of the strategy, and so the graphic summarises the 5 project components for the cultural landscape strategy, namely nations are resilient, nations speak for country, nations plan on behalf of country, nations manage on behalf of country, and knowledge is restored. Are those all interrelated and necessary components for traditional owners to meet their aspirations for protecting cultural landscapes?
I think they all work together, and they've been designed specifically to do that. And just looking at the diagram and the circle, that people are strong, country is healing, culture is strong. They all interrelate, and I guess it comes back to my first statement around the holistic nature of an Aboriginal worldview, and how we need to address and understand that interrelatedness. But it also works to address some of the, I guess, some of the challenges that are still contributing to traditional owners' ability to be able to undertake those cultural practices and have power and authority to manage those practices. And some of those things address the issues of dispossession, whether that be the loss of language, the loss of and not its entirety, as we all know, language has been heavily impacted, and it contains our knowledges, it contains our stories, it contains our understanding of country, and so we need to be able to ensure that all these components are working together, that traditional owners are able to recover those knowledges, such as language, and and land management practices that build on the existing knowledge that's been passed on through generations, and to be able to test that knowledge through research partnerships, to be able to apply those practices and to continually learn by doing on country, and to be able to address those the capacity and capability, the capacity issues across both sides of the desk, I think, in regards to government and traditional owners, and to have a deep understanding of what those needs are, and work together to be able to resolve those challenges. So it all needs to happen all at the same time, and that's the intent of the strategy, is that all of these things need to occur to achieve that broader outcome that traditional owners are seeking.
And I just want to go to component 4 in the strategy. So if we can bring up page 36 of the strategy. And so this is embedding traditional owner knowledge and practice. And so the component objective is to embed traditional owner knowledge and practice into policy, planning, and the management of country. And this builds on part of your previous answer around the relationship between the state and traditional owners. So the component areas include institutional arrangements of the government are enhanced to reflect traditional owner rights regarding management of country, two-way capacity is developed, and co-governance arrangements are in place. And so the outcome is the Victorian government policy, legislation and procedures enable and embed traditional owner knowledge and practice across all cultural landscapes. Is that really connected to to what you were just discussing in terms of the need for there to be a shift on the part of government's institutional arrangements to provide for the embedding of Indigenous knowledge and the capacity to care for country?
Absolutely, and I think just something that comes to mind is around traditional owners' objectives towards working towards sole management. Currently arrangements for joint management. However, aspirations do exist for sole management as a tier 1 land manager, similar to Parks Victoria. So when you think about institutional arrangements, what does that look like? How do we work towards that? How do we have that shared understanding of that journey that we're going on to achieve those types of aspirations for managing country?
And I was going to ask this a bit later, but you've mentioned it, so I'll ask now. That's something that the submission also talks about, the need for a shift from joint management to sole management for traditional owners, and that being a key aspiration of traditional owner corporations. Why is that so important?
I think it goes back to about our obligations to our ancestors to continually care for, have authority over, and manage country. So it's an objective of traditional owners to meet that cultural obligation, but it also contributes towards ownership, authority, self-determination, economic prosperity that is created through those types of mechanisms that will support traditional owners to become strong entities in all across the state, particularly regional parts of Victoria, that will contribute to economic activity, employment, health and well-being. So there's broader objectives that are at play here, but ultimately, I think having that sense of power and authority and decision making to be able to undertake those obligations without any impost of government directly relates back to that responsibility, that power and authority that traditional owners once held prior to colonisation.
And there's a really interesting observation on the next page, if we can bring that up, and just highlight that very last paragraph on the right side. And the last two sentences say, legislation contains specific clauses that address the exceptional status of traditional owners as partners with the Victorian government with specific rights. However, the overall framing continues to regard activities conducted by traditional owners on country as impacts on the environment to be regulated. I just wanted to give you an opportunity to expand or provide examples of how that plays out for traditional owner corporations in practice in terms of caring for country.
I think often those types of activities that are occurring on public land through joint management and the like are often biased towards biodiversity outcomes, Western views of land management, and the limitations through cultural fire and the I guess the utilisation of resources to support economic activity are all kind of limitations that exist, and even I guess I think about water as well, and environmental flows versus cultural flows, and it still seems to be a challenge for government to accept that cultural flows deliver environmental outcomes. The reverse is not true, that environmental outcomes don't deliver cultural outcomes, but cultural flows can deliver both cultural and environmental outcomes, and that's what traditional owners are seeking in the water space for those opportunities. And I think Water is Life probably addresses that to be able to enable that to occur, but it's still yet to be fully realised. So I think that by implementing the cultural landscape strategy, we can work towards recognition of traditional practices that are recognised as formal land management practices, if you want to put it that way.
And if I can go then to page 39, so it's just 2 pages on, which really shows in a graphic sense what you've just described. So you have government policy and planning instruments on the left, and then you have cultural elements on the right, and then potential bridging tools that bring those two pieces together. So even if we look at the third line, that under statewide level policy instruments, you have the government policy of reformed public land legislation, which is proposed in regional forest agreements, and then the cultural element is the application of traditional knowledge and practice in healing and managing country. And then, just as you've been describing in some of your answers, a bridging tool to bring those two pieces together would be a traditional owner corporation being the land manager. So I just wanted to allow you to explain to the commissioners about how the strategy is designed to attempt to draw together what you've just discussed in terms of traditional owner cultural aspirations and state policy.
Cool. The strategy is designed deliberately in that way, and across all the 5 component areas that looks at a traditional owner element, cultural element, as on the screen, the government planning instruments, and what needs to sit between, or what are the outcomes through that partnership and working together that's going to deliver on those shared objectives, let's call it, and then and that's how the bridging tools has been designed to be able to provide examples of what that might look like if the strategy is successfully implemented.
And on implementation, the strategy is purposely high level, and it says directly in the strategy that there's a requirement for an implementation plan to track after the strategy, and a desire for support to develop that implementation strategy. Implementation plan is directly in the strategy. Has the Federation received any commitment by government about the creation of an implementation plan?
Yes, the department is alongside traditional owners has supported the Federation to facilitate the initiation of the cultural landscape strategy through the development of a monitoring and evaluation reporting tool that will measure its progress, as well as to facilitate capacity building and communities of practice amongst traditional owners to guide and to support co-governance arrangements to guide the implementation of that strategy. And I understand that DECA has directly supported traditional owners to be able to participate in that process.
How far along is that?
Just thinking, I think it's 12 months, somewhere around there. I haven't got the dates at hand, I'm sorry, but it's probably at about 12 months, and the funding commitment is only for 2 years. So clearly there will be further commitments that need to be made. However, the initial commitment has been for 2 years to initiate.
There isn't actually an implementation plan or an evaluation plan existing right at this moment.
There is an evaluation reporting framework or tool that was produced by consultants that Federation engaged to produce that tool to be able to track progress of the implementation.
Has that been deployed, or has it just been developed as a tool? Because I note here that it says here that by December 2025, you will have achieved some of these outcomes. So how likely is it that by December 2025, because from what you're saying it still actually hasn't been, there's been no movement across to actually translate and implement?
Not in its entirety. I think there was definitely a delay in the beginning of the implementation, and it was only through our advocacy that implementation got underway. It was.
So who's responsible for this plan, for its implementation, its monitoring, and ensuring that it actually delivers what it says it's going to deliver?
So that it's joint responsibility between traditional owners and partners, between DECA and Parks Victoria, are all partners to the development of the strategy. Therefore, the commitment is to work together going forward on the delivery and the implementation of the strategy. But it obviously requires resources, and acknowledging that there are challenges in regards to capacity to participate, but there's no indication of future funding at this point in time. Not any information that I have available to me, but also participated in a cultural landscape symposium on just last Friday, where the Department of Premier and Cabinet introduced a pilot program that they call SAHA, Strategic Aboriginal Heritage Assessments, which by my analysis is basically a reading country program, which allows traditional owners to go out on country and understand, capture those values and self-determine how they collate and use that information to be able to respond to future activities on their country.
Just as a final thing, I mean, I think this is a pattern we've seen again and again and again, where there are wonderful strategies developed with huge amounts of effort and work from traditional owners, and then nothing, as if the strategy itself is the outcome.
There's a common theme amongst government strategies and policies. I think there's probably several elements at play. I mean, the cycles of government, budget processes that don't allow government to commit beyond 3 years. There needs to be agreements that could be established through treaty, perhaps, that commit secure funding regardless of government.
I'm just wondering if any other sector of the Victorian population has this pattern with strategy after strategy, framework after framework, that result basically in non-delivery, and beautiful artwork. But it's just, it breaks my heart to see that all this work has been put in, but then for no follow through, as if somehow job is done because we have a strategy, even though we've not put any resources or any responsibility in actually achieving that strategy.
Certainly is a pattern of behaviour. My mind goes to the cultural fire strategy, which proposed a implementation budget of $122 million. The government provided $20 million across all traditional owners, and nothing further. So is it going to meet its objective? It's the desired outcomes? I think not.
When is it time to say we're not going to do another strategy until you've completed the last one?
Interesting. Mine goes to just something that's been learned by me in my closing the gap participation as well, which is a Treasury process, which is the early intervention investment framework that doesn't consider these types of activities as early intervention. And I raised that with Secretary of DTF. When you think about what's contained within that framework, I'm not sure if the Commission has looked at that, but it looks at health and wellbeing and what are the sort of early interventions that government can invest in to support those types of outcomes. And healing country, connection to country, Aboriginal wellbeing, and family supports, although maybe not family supports, healing country type activities are not anywhere mentioned in that framework as a preventative measure. And that's what's when there are budget bids and that's what gets used as a tool for decision making for budget allocations.
I want to briefly now turn to the Federation's Native Foods and Botanicals strategy. So just while we're getting the vision and purpose drawn up on page 6 of that strategy, the strategy mentions that the value of the Native Foods and Botanicals strategy is approximately $50 million per year in Australia, but has growth potential upwards of $250 million in the near future. But the strategy also interestingly notes that while there is, in some parts of the country, significant Indigenous engagement in growing raw native foods and botanicals, there's very little Indigenous ownership of enterprise that then sells those goods. Do you think that the industry represents a potential economic development activity here in Victoria?
I think there's a significant opportunity for traditional owners to assert their place in that industry, given that the knowledges that's traditional owner knowledges that support that industry are not recognised and have not been addressed and need to be addressed. The strategy looks at intellectual property and how traditional owners have not been recognised for that knowledge and how you attribute that knowledge to provide benefit, but the growth in the industry and the value add that is also part of this conversation when you look at an industry that's already well established, and how do traditional owners kind of catch up in regards to an industry that's growing at a rapid rate and they've left behind. So what are the kind of the approaches that can be applied to enhance economic outcomes for traditional owners in this space? Intellectual property is one. We also produced a set of protocols, I think that's been provided, that is an attachment to the strategy that sets out the relationship that should be established between the industry and traditional owners to provide benefit, provide business arrangements to be able to recognise that through provenancing, Indigenous partnership, and knowledge that is contained within those native food materials can provide a value add to the industry, in that the consumer is prepared to pay a premium to have that story, to have that knowledge as part of that product. So the protocol sets out a template agreement that traditional owners and existing businesses could enter into, but also alongside that is the opportunity, and there are already traditional owner groups who are developing their businesses, doing seed collection, growing plant material that supports local cafes. There's even a consideration towards a cooperative that traditional owners have identified to be able to kind of come together, bring those plant materials together in a cooperative arrangement that can then supply the market to bolster up that kind of positioning within the market. So all those sort of things are being considered through the strategy. But I think we need to position traditional owners in a way, because intellectual property typically is a Commonwealth jurisdiction, I think, at a national level, and there's not a lot of appetite, but there are encouraging signs, because the Commonwealth have undertaken an intellectual property investigation, particularly around art and dance, that could be expanded out to areas such as native foods and botanicals, that recognises traditional owners as knowledge holders and owners of that story, of that knowledge, much like dance and art are, and reimagine within the community about traditional owners' place in that industry. So it's not, I guess, in addition to that, it's potentially given the depending on what the outcomes might be at that Commonwealth jurisdictional level, if there are still no recommendations or reforms in that space to be able to support native foods and botanicals for traditional owners, could potentially be a treaty item that could be recognised through recognition of flora rights or something of that kind.
And I'll just show the graphic on pages 12 and 13, which essentially summarises the evidence that you've just given. So there's a connection between the provenance, which is about the protection of Indigenous cultural and intellectual property practice, so to build capacity in Indigenous communities and to apply Indigenous knowledge across the supply chain, then also participation in the market. So all of those, as you've just described, all of those things go hand in hand in terms of Indigenous aspirations for that industry.
So they all need to, again, happen at the same time. That is not always the case, but if there's a sequencing to that, then that would need to be, I guess, considered. But like I said, we're playing catch up with an industry that's already kind of well established, or it's establishing and growing at a rapid pace. So we need to do whatever we can to be able to meet those expectations and consider the rights of traditional owners in this space.
Can I just ask, how far along is this strategy? Like, where's it sort of at, or where's the funding at, or?
There's just trying to jog my memory. It's several years since it's been established. I think 2020, the end of 2020. It was just after I'd started at Federation. So it's been supported up till now by AgVic, and that funding is soon to dry up. And only part of the work's done. We've got protocols. We've got looking at, like I said, intellectual property, and there was some business grants to support businesses to be able to scale up their businesses and build capacity, but that was a one-off kind of offering. There's been, I guess, a policy shift with the change from AgVic sitting in one department to moving to another, and that department has a different approach to how it supports initiatives such as this, and that's had an impact on future activities to support the implementation of the strategy.
And did the strategy come with any land? Have any of the strategies come with any land? Because they all revolve around it.
No.
And then the funds drive. I'm particularly concerned about that you're the conduit, right? And that you have to go and get the information from traditional owners, which is all good and well, but then it doesn't get implemented. So where does that leave you as the sort of holding body of knowledge, like as the corporation? Where does that leave you with traditional owners? I mean, that could leave you in a bit of a bind at times.
Yes, I think we always undertake the approach of looking to extend the strategy, ensure that it meets its full implementation, and I guess what we'd like to see is a long-term commitment, but alongside that, we need traditional owners to be also advocating for that continuation.
Yeah, I'm just there. Nothing comes with land. That's all. Just
a perfect preface for discussion of the first principles review, Commissioner Hunter.
You go.
But sorry, Commissioner.
I'll just ask one other thing. Yeah. You're showing great diplomacy. Say that.
You know what I mean?
Good point.
The Federation, get funded money from the government to be able to work with traditional owners. You don't? To be able to develop these strategies?
Funding gets provided for those strategies.
Yeah.
There is no core funding for Federation.
From the Victorian government. Thank you. That's good.
So the final topic I wanted to ask some questions about is the first principles review. Could you briefly explain the background to the review?
Well, the first principles review was initiated in 2020, early 2020, I believe.
In terms of reference, was signed off by Cabinet in October 2019, and then I think it kicked off formally in 2020.
Yeah, that's why I was a little bit hesitant there, because I thought exactly the same thing. And it was based and initiated by traditional owners wanting to reconsider the principles and the outcomes from the Traditional Owner Settlement Act. It had passed 10 years since it had been established. So back alongside the findings of Timber Creek in the Northern Territory and the compensation formula, those two events occurred at the same time, and traditional owners, through advocacy of traditional owners, the Attorney General at the time, Jill Hennessy, agreed to establish the First Principles Review Committee to work with government on reviewing the Traditional Owner Settlement Act under those broad objectives.
And the governance arrangements for the review were that there was a First Principles Review Committee made up of Victorian traditional owners and an Executive Policy Owners Forum made up of senior executives from government departments and agencies. That's right?
That's correct.
And the report's structured in such a way that there are recommendations made that are joint between the committee and the forum, if I can put it that way, and recommendations that are individual to either the committee or the forum. That's right?
Correct.
And so I just want to go first to the terms of reference, and in particular to the scope at pages 89 and 90 of the review. And so those are highlighted there, and it appears that these really set out a number of the concerns of Victorian traditional owners that led to the review. Is that right? And so you'll see there that there are particular issues under natural resource agreements, which might form part of the settlement package under the Traditional Owner Settlement Act. And you'll see in the second dot point under that heading, restrictions on access to flora and fauna. You've just mentioned that in the course of your evidence. And then the fifth dot point, the commercial use of natural resources, something else you've mentioned in your evidence. And then under land use activity agreement, which is another agreement that can form part of a settlement package, there's reference to the community benefits formula in light of Timber Creek and some other issues. And then in the next heading under recognition and settlement agreement, there's some further dot points, including the first, review mechanisms, the third, compliance with obligations, fourth, enforcement of compliance, and then fifth, the funding agreement. So, and then implications of Timber Creek with respect to negotiation of settlement packages. So, am I right in saying, from your perspective as CEO of the Federation, that these are generally some of the concerns that your members have in relation to the operation of the Traditional Owner Settlement Act?
I would agree. That is correct.
So I don't want to take you through, obviously, the entirety of the report, but I want to focus on some key recommendations. So if I can bring up page 76 of the report, these are the recommendations. And in particular, I just want to focus on recommendations 1 and 2. So first, it was a joint recommendation of both the committee and the forum that Settlement Act agreements should represent a fair and just settlement. That's right. And that's a change from the current policy, which uses the language of an attractive and fair alternative to settling claims through the Native Title Act. That's right.
Correct.
And so why is that change important from your perspective at the Federation?
I think the addition of just is where the focus is on that recommendation. Clearly, we need to. It goes back to earlier comments. Address the injustices of colonisation and traditional owners' ability to have power, authority, and actively manage the country, and therefore that term "just" needs to recognise the significance of the impact in the settlement that's agreed to ultimately, and yeah, it needs to consider that appropriately rather than some kind of attractive and arbitrary outcome that, if we're talking versus, I guess, compensation, it's a monetary compensation, and then more broadly rights and so forth that can be included in that agreement, then that contributes towards just outcomes.
Now, there's a qualifier that immediately follows in terms of recommendation 2. So recommendation 2 was not joined by the state, but states that calculation of compensation should not be limited to activities occurring post-1975. Now, that's a response to the fact that under the Native Title Act, compensation is only available for acts attributable to the state that occurred after the enactment of the Racial Discrimination Act. Do you understand that?
I do understand.
And so why is it important to Victorian traditional owners that compensation be available for acts done prior to 1975?
I think my assessment of the connection to that time is that through that act, there are protections through that act that need to be followed by government to not racially discriminate against Aboriginal people. However, my view is that prior to that time, most of the impacts occurred that have led to the legacies that we continue to experience today. They all of those acts occurred before 1975 and set the foundations for way that we're able to practice and exercise and activate our rights. So it seems that is not being recognised, that those impacts are not being recognised prior to that date.
Have you got any more you want to share about the ongoing impacts of colonisation pre-75. You've shared a few, but I just want to give any further chance to elaborate any more in, particularly around that for traditional owners.
Well, one that comes to mind, language, obviously.
Yep.
The prohibiting of speaking language, and the impacts that continues to have today on people's ability to speak language, to be able to understand language, to be able to access knowledge and connections through language. Think about the movement of our people across the state to mission reserves from one end to the other, and disconnection to country, to family, to those stories that people are still finding their way home today, and that's still directly due to those types of policies, those activities that continue to affect our people to this present day.
And have you got anything further to say around the wealth that's been generated by non-Aboriginal people during that time, as in pre-75?
It was, from my understanding, a granting of property, freehold title to graziers, to farmers, to people at that time that have been held in those families through generations, and that has created intergenerational wealth that still exists today, and that wasn't afforded to our people at that particular time. There was, as our people were moved out of towns into missions and so forth, those types of acts inhibited our ability to build skills and participate in the community, in the economy, and that set up a cycle of disadvantage that continues to affect our people today.
Thank you.
If I can go to pages 28 and 29 and building on your interaction with Commissioner Lovett. Pages 28 and 29 go into a little bit more detail about the difference of opinion between the committee and the forum regarding this particular recommendation. And I just note in the second paragraph under the committee's comments that the committee stated it believed that limiting the ability of compensation until after the enactment of the Racial Discrimination Act is entirely arbitrary, inequitable and unjust, and recommend that it should be abandoned by the state. The colonisation of Victoria and the dispossession of Aboriginal people from their lands largely took place prior to 1975. So that encapsulates your comments as well. I note that the state does say, the forum comments in their second paragraph is, additionally, it is foreseeable that compensation for loss or impairment of rights as a result of actions prior to 1975 might form part of future treaty negotiations. Are you, while that might be correct, are you concerned that the government is in effect pushing consideration of this matter to the treaty process?
I think that I think treaty is going to consider a range of kind of rights and redress and compensation, and I think to consider it broadly is something that allows, in that negotiation, the ability to balance out those outcomes between redress and rights and recognition and commitment towards future education can all be addressed at the treaty negotiation table.
So just a final and second recommendation I'd want to discuss is recommendation 18. That's on page 45. So it's a joint recommendation that the Settlement Act and the Natural Resources Agreement template be amended so to accommodate the commercial use of animals other than fish, to create parity with the provisions providing for commercial use of vegetation, stone, etc. So just by way of background, my understanding is that traditional owner groups have the capacity to negotiate commercial use of vegetation and stone, but not of animals in the current situation in terms of settlement agreements. Is that right? And it's not an immediate right, it's just simply the right to negotiate that with the state in the course of settlement negotiations. And then it was an individual recommendation that by the committee made up of First Peoples that the commercial use include fish. That's right. If we go on to the next page, on page 46, if we go to the final paragraph under the FPRC comments and highlight that. So the penultimate paragraph, yes, thank you. So the committee explains what we've just discussed, essentially that there's a desire to be able to negotiate on both vegetation, stone and animals, including fish. And that this wasn't a request for the right to do so, but the right to negotiate it as potentially as part of a settlement agreement. And then the committee notes, in other words, the request was conservative and the exclusion of water and fish is not a reasonable exclusion. In doing so, it does not so much prevent traditional owners exercising commercial rights over these resources, but instead prohibits even any negotiation or discussion about doing so. The committee is disappointed and disagrees with this exclusion, particularly in circumstances where native title commercial rights continue to be explored through the courts. Nevertheless, the committee has endorsed the joint recommendation in the hope that at least some minor and limited change can be achieved. Given all we've discussed about economic empowerment on country and particularly thinking about the native foods and botanical strategy that we've discussed and those issues, are you disappointed that that even a conservative request, particularly to include water and fish in that regard, was not agreed to?
I'm extremely disappointed by the response from the state in regards to not even including the ability to negotiate around those areas. I think there's probably some I guess considerations around the size of those economic activities. I mentioned before water, the value of water, and I don't know, but I can only imagine the size of the aquaculture and fishing industry, and it seems to me that the state is kind of protecting those assets, and knowing the value that provides to the state's bottom line, then that's the only conclusion I can come to in regards to why those are off the table, and I don't think it's up there, but somewhere else in there, the response is somewhat from fisheries is somewhat opaque and doesn't provide an adequate reasoning as to why the fisheries have been excluded from being added to the list.
My final question is just about the review as a structural one, about the institution of government itself. There were some comments by the committee, and if we can bring up page 18 of the review and highlight the third paragraph. I won't read it all out, but I'll commence from the middle. It's a statement that there were long delays while the forum considered positions put forward by the committee. Presumably this time was spent in internal debate, and while it is understood that whole of government decision making is complex, viewed externally from the position of the committee, an excessive amount of time was spent on issues long articulated by traditional owners and for which it was assumed forum members would be well versed and ready to propose alternatives. Indeed, it is notable that some departments sought to amend recommendations and add last-minute conditions up to and during the final drafting of the report when there was no time for further discussion or debate. Are you frustrated by the fact that First Peoples made that comment in relation to the review? And what does it say to you about the institutional capacity of the state to deal with First Peoples' aspirations on land justice?
I think the state doesn't have a good understanding and of traditional owner self-determination and the rights that are afforded to us through UNDRIP. It hasn't invested in its own capability to be able to understand self-determination, not to a level that needs to reform departments and agencies to activate our rights, to identify and address policies that don't meet the minimum standards in UNDRIP. And there continues to be a misalignment with, and I guess it's understandable in some ways, that the holistic nature of an Aboriginal worldview versus Western worldview continue to not align. And then therefore you see the types of institutional structures within government that are unable to kind of grapple with a holistic worldview, and that continues to impact on our ability to address these shortcomings within legislation and policy, and often deliberate policies that exclude traditional owners, and it's also probably coupled with vested interests on behalf of the state.
Commissioners, I'm going to move on from the review, so I wanted to pause in case there were any specific questions.
Yeah, just on that, I think you're being very generous, very diplomatic. But without really understanding the whole process of this, what would you say to all the self-determination policies and the talk of self-determination within government, and then you get this response? What would be, and don't be diplomatic. Can I say that?
Again, there's a lack of investment. There's certainly a recognition that these self-determination teams, divisions, groups have been set up, but they're not sufficiently supported and resourced to make an impact at a departmental level. I worked in the department, and
I think you're being generous. Do you think they understand self-determination?
No, I've been saying it for years to government that government and the public service doesn't understand self-determination, and that needs to invest considerably in shifting the psyche of the public service and having and developing a deep understanding of our rights and self-determination, so that the public service can do their job and deliver on the commitment of government to enable self-determination for traditional owners here in Victoria.
But it's not that hard, is it? I mean, we have UNDRIP, we have all these things. So that there is a real gap between what is very clear, what self-determination is, it's been defined, and the strategies, and a complete lack of action.
Yeah.
So this isn't just a matter of education. It goes much deeper than that. It seems to me that there is a lack of willingness to actually move over that line from talking about it to doing something.
Absolutely. I understand it's a significant piece of work, but there needs to be the recognition for that to occur, and for that investment to support and work towards that institutional shift, that capability shift, the capacity shift that needs to occur, and without it, we'll still be here subject to government's interpretation of self-determination, which we often say is just more engagement, and not the handing over of rights, power and authority to our mob.
2014, Victorian Aboriginal Affairs Framework came out, and one of the top guiding principles is self-determination. 2014, so what's that? Let's say about 10 years ago? Yeah, 2024. We're in 10 years to get their head around self-determination. It's just, quite disheartening. But I just want to take you back to a place where we were talking before about the recommendations being changed and government trying to interject last minute around what they wanted to see in there. Can you describe, without naming anyone, can you describe the sentiment amongst yourself or the traditional owners about, or the working group, about how the mob felt when they put their heart and soul into that work and work really hard on behalf of all mobs to try to get really good outcomes for the future? Can you just talk a little bit about that?
Guess it brings back, experiences of similar, responses from government, a lack of respect, the under communication, if you can call it that, was actually in breach of the terms of reference for the review, and to then not have come with an outcome such as this, with one agreed and all but 7, I think I've got that right, all but 7 agreed in principle, but obviously again, the caveat is that there needs to be further consultation, and yet those policy owners were part of that process. So it just shows a lack of respect, and traditional owners just feel that they've just getting the same service from government that they've always got, and you can never hold your breath around government coming to the table genuinely to work together and make commitments that it will follow through with.
Yeah, because of what people in society don't realise. When you negotiate traditional settlement agreement, you also negotiate or forego future rights. So you're trying to really pin down the rights and opportunities for, how you can make sure that things can happen through that negotiation. It's just really disheartening here when there's active attempts, as we saw yesterday, around our people's rights being respected and upheld and implemented.
And if I can respond, and I'll just reflect on the earlier conversation Commissioner had with the Assembly in regards to accountability. And, you know, one of the, I guess, conversations in the review was around where afforded rights had been agreed to within those agreements. When they're not being met, there was no accountability to government. There's no one, and the same happens with the delivery of the strategies or any of that. Government will bat it away and say, you know, we'll do better next time. And you know, you can write out your media statements, and you may or may not get it picked up. And you know, government doesn't seem to be too concerned. Mostly, I wouldn't say 100% of the time, with those types of attempts to hold them to account. I think going forward in treaty, you know, we have the authority as a independent arbiter, and those agreements that are being made in treaty, and it's probably an answer to the question earlier, is where those agreements in treaty are not being implemented, realised, then where does that accountability sit? Does it go back to the authority? How do we ensure that there's an accountability mechanism there, and that there's a significant impact on, let's say, government if they don't meet that agreement? That can't just be, you know, dealt with through sorry.
That leads well to my final question. What are your aspirations for the treaty process in Victoria?
I think then quite broad. I think that, you know, there needs some of the picking up from some of the previous comments, but there needs to be recognition of our past and a commitment to address those truths that come out through this process and through treaty. There needs to be I guess I'm not going to say rights, but a range of outcomes from treaty that addresses some of the inequities, the rights. There needs to be a compensatory element that addresses those economic opportunities that haven't been able to be realised. And I think, and going forward, that, you know, that there needs to be recognition of our place in society and how we walk together as a country going forward, as a community, and that we're ensuring that we're tracking how we're going and having a relationship that can make adjustments along the way, and that's embedded in UNDRIP, that it meets that UNDRIP is embedded into the treaty agreements. It's embedded into policy and legislation, and even potentially what's the word? Justiciable. I can't say that word. Justiciable rights that could be introduced where our rights are not being met. So I point to British Columbia, where they've introduced those types of rights into legislation. So I think the the future is bright, but it requires a real commitment on government to walk this journey together with openness and honesty and commitment.
Those are my questions, Commissioners. I'll just attend to some tendering. I'll tender the First Peoples Assembly submission that was relevant to this morning's evidence. I'll also tender the submission of the Federation, the two strategies that we've referred to, and the particular poster of the landscape as well. So, yeah, thank you. That ends our afternoon session, Commissioners. Thank you.
Thank you. Thanks very much. Thanks for coming in. Appreciate the time. Yeah.
I believe we're adjourning now till tomorrow. So,
okay. Thank you. The Europe Justice Commission is now resumed.
If the Commission pleases, I will now ask for a pre-recorded video of Uncle Jim Berg to be shown on screen.
Yes. Thank you, Council.
My name's Jim Berg, Gunditjmara elder. I'm 86 years old and I'm here to make a statement on who I am and what I am. And I've got a couple of poems here just to build up on my submission in relations to my background, this is about my dad. Where are we going, Mum? And she led me by the hand and started to walk down Napier Street, Fitzroy. We're going to see your dad. Where is he? Replied the 4-year-old. He's down in the cells of the Fitzroy police station. Why? Says I. I was told that I talked too much and then was ignored. There he lay behind the steel bars of the cell on a cold concrete floor covered with a blanket over his head. Dead drunk was he. Not a word was said that I can recall as we walked out of the police station doors. I never saw my dad again. It was at Framlingham Aboriginal Mission when I was 10 before I heard my dad again. It was a stormy, wintry, thunderclap night. The rain came down like a river in flood. Us kids lay between the blankets, curled up to keep warm. It was a 6-dog night. The thunder that rocked the house was replaced by another sound. It was a drunken voice outside the front door. Let me in, let me in. And then the fist and the boot hammering and kicking the door. Let me in, let me in. My mum yelled out, go away and leave us alone. Go away and leave us alone. The hammering and kicking of the door continued. The drunken voice got louder and was yelling out, let me in, let me in. Us kids shivered under the blankets, not from the cold, but from fear of the unknown drunken voice behind the front door. Mum called out to us kids to hurry up and get out of bed. We have to go. We all left with nothing but what we wore. No time even to put on our shoes. The last thing we heard as we fled out through the back door was the fist and boot hammering on the back door and the drunken voice yelling out, let me in, let me in. We fled down the rain-swept muddy road to Arnie's place a couple of k's away. Down the road, Mum told her auntie and uncles that our dad was drunk and was trying to break down the front door. Our 2 uncles left to sort him out. I learned years later that the uncles found my dad staggering across and down the road. He had both of his arms held out in front of him. They saw blood running from his 2-slashed wrists to his fingertips into the muddy, rain-flooded road. He had broken the windows in his attempt to break in, and some broken window glass was embedded in both wrists. He disappeared after this night. We never knew where to. During my early years, I was known as a Clark with an E, my mum's maiden name. As a teenager, it didn't feel right, and I felt guilty that I denied my father's name, which was Berg. Over the years, I often wondered about my dad and his family. None I ever known or seen. I was told he was taken away from his mum and became part of the stolen generation. He was like thousands of other Koori kids who became of the stolen generation. They lost their identity, language, dignity, pride and spirituality. They filled the prisons of today. Who should we blame for what they turned out to be? My sister saw her dad before he passed away. Rest in peace, Jim Berg Sr. I'm proud to bear your name. My message to the young Kooris of Victoria. Young Koori of this land now called Australia, you are the custodians, educators and ambassadors of the oldest, continuous and resilient culture in the world. Stand tall. Maintain your culture, language, identity, spirituality, dignity and pride. Be proud of who you are. May the spirits of my ancestors be with you on your life journeys.
Can I just ask you about because I know you had a lot to do with it, the repatriation and making sure people respectfully, and I really honour that work that you've done for those that, you know, making sure they're back home and they're safe. And if you're okay with that,
I'm okay.
I would like you just to talk about your part you took in that, because I think that's really honourable work, and there's not many people that would do what you did, Uncle Jim, and I would like others to hear about that work.
Well, I've walked in the steps of my ancestors, like Stuart Murray, yeah, and Auntie, what's her name, the one in the wheelchair?
I'm not sure you're
Oh, it'll come to me. They, back in the 50s, approached the state government in regards to the repatriation of ancestors. So, Jackie come late because that was in the 50s. Nobody knows about it or don't want to know about it. It's in the book. Only Marge Tucker, both of them, wanted the repatriation of ancestors back to their country. It didn't happen. When I was in the Aboriginal Legal Service, as a CEO, the government made me an inspector under the Archaeological Preservation Act, 1972, and that empowered me to be on the committee to make decisions in regards to Aboriginal culture. And one particular day, Joel's Auctioneers down at St Kilda, one of the big ones, they was having an auction of culture material from South Australia, treasures, antiques of our people, masked, yeah. And I was told that under the legislation, they should get permission. They didn't. So, as the inspector, I seized all the material. It was on the ABC. And went to court. But before that, I was holding the meeting and I told the government, the Labor government at the time, that they should prosecute Joel's Auctioneer, and got a reply back to say, we're not going to prosecute Jim because we prosecuted two other auctioneers for the same thing and we lost the case and we're not going to lose a third one. So, me being me, I said, right, if you don't change your mind, this is about 1 o'clock, by 3 o'clock, I'm going to prosecute you, the state government, for not fulfilling their obligations under the Act to prosecute. 3 o'clock, you know what a telegram is?
Yeah, that's a while ago though.
Yeah, you're that old. And they said, proceed, Jim, to prosecute. Pick your own team. And I was told by my team, Ron Merkel and Ron Caston, that the chances were that I wouldn't succeed. I said, big deal. There's an act there. We've got to prosecute. Took a week. I was in the stand for 2 days. We lost, as predicted, but the act was changed, where museums and universities, keeping places, had to get permission from the government before they can proceed with selling or loaning material. And somebody came along one day and says, Jim, the museum is sending the cow swamp and the Kilo skull to America for scientific exhibition. I said, oh yeah. So I hit him with an injunction with my mate, Ron Merkel. We're still friends after 50 years. And they didn't send the material to America because they were prosecuted. They didn't have permission. Back in those days, anybody who wanted a loan of material brought them back and just dumped them in the back door of the Swanston Street. Just left them there. Then somebody showed me a magazine of the University of Melbourne, the Murray Black collection, 800 remains. So I flexed my muscles again, legal muscles, and we prosecuted them. The Gary Bamblett and me went across, I have to tell you this, went across to the university and went up to Professor Carra's, the Vice-Chancellor's office, and kept us waiting outside for 10, 20 minutes. Walked in and he was standing there with another gentleman beside him and handed him the injunction. He looked at it and gave it to which turned out to be a solicitor. He said, it's kosher. And Caro said, who in hell do you think you are? We are the Museum of the University of Melbourne and we own these remains. They're ours. And I had the injunction, I took the injunction off him and I held it up in the air over my head and I said, I'm the law. And his other individual, David Pennington, I went there to hit him with another injunction because he was in charge of the anatomy department. And I had him on the phone, we discussed it and he said, who's your superior? And I said, what'd that mean? In broken English. He said, the person's over you. I said, there's no person over me, mate. And he hung up gently. We became friends after that. Yeah. So we had the Murray Black collection transferred to the Melbourne Museum. The university approached the state government in regards to being declared a safekeeping place for ancestral remains because it was the largest collection of Aboriginal material in the world and they didn't want to lose it. And the government had to come to me because they set up a little committee to overview the request and I just said no. So all that material returned back to country. And I had the honour of sitting down in my office and big Johnny King, and I mean big, came up and tapped me on the shoulder and says, Uncle, don't say a word, come with me. And I had the pleasure of going down to Latrobe Street to put the last box of the Murray Black collection on the semi-trailer. It was during those periods that the museum had skeletal remains unprovidenced, 38, which represents 38 clans in Victoria. Yeah. So they were wrapped up in paper bark and there was a couple of hundred people marched down Swanston Street for the reburial site. Prior to all that, I spoke to the Melbourne City Council and they said, well, you can make a presentation to the full committee about a site. And I went down and sat outside and the gentleman came out, if you're Jim Berg, I said, yep, you got what you want. Pick any spot in Melbourne. And I chose that spot.
King's Domain spot?
Yep.
Yeah.
And I wrote that poem at a very boring meeting. Yeah, yeah. And it has the same protection as the Shrine of Remembrance. The same protection. Yes. So over 200 turned up. Yeah. And then the government wanted assistance to set up the Cultural Heritage Council. And that happened. That happened just like that.
Thank you for sharing that story, because there's not many people that actually know it. I know you're very modest in how you, but people know there's remains there but don't know the story behind it. And I think it's really important that we share how and why that is a place, because I don't think, one, there's many mob that understand that, but also the wider Victoria don't understand that as well. And I think that story's important.
The Mildura mob found a site up along the Murray River. 800 people were there, lying on the sand, exposed on the sand.
Yes, yeah.
So they found 3,000 so far. Wow. Yeah, saw the young fella yesterday. And straight after that I wrote a poem, Where Are You My Children, based on what we saw. I don't like looking at ancestors' remains, not even on TV or even in newspapers. And I had people protecting me. Yeah, supporting me, out of sight. Yeah, when I wrote that poem on the way back from Melbourne, Where Are You My Children, that relates to that burial site. Murray Black, when he was asked to find some Aboriginal remains, went along the Murray River and dug up 3 burial sites. Several years later, they found Lake Victoria was dry. 10,000 graves. 10,000 graves. He would have had a ball.
What about all the things you've told us about Uncle Jim? From, you've got lots of things that you've been part of. Told us about connecting hundreds of people to their country and community and their family, and setting up bells and crew courts and prisons. And is there one thing that you look back on that you're most proud of?
Most proud of? Yes. My soulmate told me I should look in the mirror each morning and shave and look my ancestors in the eye and say, have I done enough? And I'm still doing that. Yeah. Yeah. And my grandfather says you will get what you deserve, so you got me today. Yeah. So I'm happy with what I've been involved in. I'm not a committee person. I'm an individual. I have a set of principles that I keep. My uncles told me that the best money to spend is the one you earn by your own blood, sweat and tears. My pop says, seek the truth. And my Uncle Banjo says, if you haven't got a set of principles, you're not a man at all. And as I said, my grandfather said, you will get what you deserve. And I keep those principles. And when I tell my uncle, Banjo, I just lost an argument with a friend, and he said, "What's your friend in the first place?" And if somebody crosses the line, I don't mind being told off one-to-one, but in a committee, as it happened a couple of years ago, in front of 70 of my peers, I was told off. I cut off and I don't speak to that person again. And my friends, communities know that, they know where I stand. Yeah. Yeah. And I stick by it. And I can hold my head up high. I can sleep straight each night. Yeah.